Good morning. The sitting is now open. The court meets this morning to hear the following participants: South Africa, Algeria, Saudi Arabia, Belgium, and Colombia. Each of the delegations has been allocated 30 minutes for its presentation. The court will observe a short break after the presentation of Saudi Arabia. I shall now give the floor to Mr. Dango, speaking on behalf of South Africa. Sir, you have the floor.
Mr. President, members of the court, it is an honor to appear before this court on behalf of the Republic of South Africa. We appear before the court pursuant to General Assembly Resolution 79/232, which requested an advisory opinion on the obligations of Israel in relation to the presence and activities of the United Nations and other international organizations and third states. This resolution was initiated by Norway and supported overwhelmingly by member states. We make these submissions while Gaza is once again under a complete siege following Israel's breach of the ceasefire brokered by the United States, Qatar, and Egypt. Israel has also intensified its aggression against Palestinians in the West Bank. Israel is blocking food, water, and medicines, all of which are essential to life, from entering Gaza. As cited in this court yesterday, the United Nations Secretary General stated that Gaza is a killing field. He added, "Aid has dried up, the floodgates of horror have reopened." On 11th April, the UN Office of the High Commissioner for Human Rights reported that Israel, and I quote, "appears to be inflicting on Palestinians in Gaza conditions of life increasingly incompatible with a continued existence as a group in Gaza." Palestinian NGOs and major aid groups have warned that Gaza is entering into famine and that in oral submissions made yesterday. We wish to emphasize the impunity with which Israel is inflicting these harms. Israel continues to act with impunity as it does enjoy some form of exceptionalism from accountability to international law and norms. Conversely, any person or entity which seeks to hold Israel to account for its inhumane and unlawful actions is subjected to countermeasures and censure. The United Nations and this court has not been spared. In this context, the United Nations Relief and Works Agency for Palestinian Refugees, UNRWA, which was established after the 1948 Nakba, is but one of Israel's latest casualties. UNRWA is being attacked in furtherance of Israel's goal to deny the inalienable right of return of Palestinian refugees, the restitution of their land, homes, and property appropriated since 1948, and to further its apartheid policies and practices. The attacks on UNRWA are also deliberately imperiling the existence of Palestinians as a group. Mr. President, members of the court, turning now to the court's jurisdiction, South Africa considers that the court's jurisdictional requirements have undoubtedly been met. In relation to judicial propriety, South Africa observes that the court had, in its 19 July 2024 advisory opinion, dispensed with the arguments raised by some states in this proceedings. The court held that the arguments did not constitute compelling reasons to decline to give the advisory opinion then. The same reasoning should apply now. In the interest of brevity, South Africa will not repeat the court's long-standing and clear jurisprudence on this aspect. Providing an advisory opinion does not require the court to prejudge elements relevant to the contentious proceedings in South Africa versus Israel, which South Africa argues, based on facts and law, that Israel is in breach of the Genocide Convention. The question asked of the court in the present matter concerns Israel's obligation as an occupying power and its obligations as a member of the United Nations, and specifically the legal consequences arising from its acts and omissions in these contexts. The court has extensive facts available to it by virtue of the dossier transmitted to it by the United Nations and the submissions made in writing by states. This is despite Israel imposing an information blackout, including through prohibiting the entry of international media and by killing journalists. Israel is also denying access to the occupied Palestinian territory to UN agencies, persons and entities mandated by it to investigate Israel violations of Palestinian rights. Accepting Israel's argument under the circumstances that this court has insufficient facts before it would be rewarding it for its own egregious conduct. Any further actions by Israel that censor remaining humanitarian organizations requiring access, UNRWA in particular, would contribute to rendering Israel's conduct unreviewable. The international community cannot accept the reality in which an entire civil population is deliberately starved by Israel, where the United Nations is evicted and deprived of its immunities and privileges, where third states and humanitarian organizations are prevented from rendering humanitarian assistance in solidarity and in fulfillment of their erga omnes obligations. Nor can we accept that journalists, aid workers, and first responders are being assassinated and then hastily buried in mass graves. The United Nations is rightly seized with this matter and calls for the court's urgent advice on the questions put to it by the General Assembly. Mr. President, members of the court, this brings to an end the first part of South Africa's oral submission. I kindly request that the court calls upon Ms. Nokukanya Jele, the Special Advisor to the President of the Republic of South Africa on Legal and International Affairs, to address it on Israel's obligations as an occupying power. I thank you for your attention.
I thank Mr. Dangor. Je donne maintenant la parole à Madame Nokukanya Jele. Madame, je vous en prie.
Monsieur le Président, Mesdames et Messieurs de la Cour, c'est pour moi un honneur et un privilège de comparaître devant vous ce matin au nom de l'Afrique du Sud. Dans un ordre juridique international interdisant l'acquisition de territoires par la force, les règles du droit international régissant l'occupation militaire doivent nécessairement être interprétées en faveur des droits de la population occupée. La bande de Gaza et la Cisjordanie, y compris Jérusalem-Est, restent sous l'occupation militaire d'Israël et le droit de l'occupation s'y applique en vertu de la lex specialis. Partant de ce postulat, le droit de l'occupation impose des limites à l'exercice.
I'm sorry to interrupt you. There is a problem with the interpretation. Yes, you can.
Should I begin again, Mr. President?
Yes.
I shall do so, Mr. President. Monsieur le Président, Mesdames et Messieurs de la Cour, c'est pour moi un honneur et un privilège de comparaître devant vous ce matin au nom de l'Afrique du Sud. Dans un ordre juridique international interdisant l'acquisition de territoires par la force, les règles du droit international régissant l'occupation militaire doivent nécessairement être interprétées en faveur des droits de la population occupée. La bande de Gaza et la Cisjordanie, y compris Jérusalem-Est, restent sous l'occupation militaire d'Israël et le droit de l'occupation s'y applique en vertu de la lex specialis. Partant de ce postulat, le droit de l'occupation impose des limites à l'exercice de facto du pouvoir de l'occupant. Il lui confère, comme l'a remarqué la Cour, un ensemble de pouvoirs réglementaires fondés sur des motifs exceptionnels et spécifiquement énumérés. Israël est tenu de respecter la vie, les droits et les biens de la population du territoire occupé, tandis que les personnes protégées ne peuvent être privées d'aucune manière du bénéfice de la Convention en vertu d'un quelconque changement effectué par l'occupation. En 2024, la Cour a déclaré qu'elle n'était, je cite, « pas convaincue que l'extension du droit israélien à la Cisjordanie et à Jérusalem-Est soit justifiée par l'un quelconque des motifs énoncés au deuxième alinéa de l'article 64 de la 4e Convention de Genève. L'Afrique du Sud soutient que les lois interdisant l'UNRWA doivent également être déclarées incompatibles avec cette disposition. En premier lieu, par le biais de ces lois et leur application territoriale directe à Jérusalem occupée, Israël prétend illégalement affirmer sa souveraineté sur Jérusalem-Est. Étant donné que le droit de l'occupation ne transfère pas le titre de souveraineté à la puissance occupante, il s'agit d'une mesure supplémentaire par laquelle Israël étend, comme l'a considéré la Cour, je cite, son annexion progressive au territoire israélien et l'application de ces lois internes dans les dites zones, entravant ainsi l'exercice du droit à l'autodétermination du peuple palestinien. En deuxième lieu, la puissance occupante ne peut exercer ses pouvoirs limités d'une manière incompatible avec ses autres obligations en vertu de la Convention, citée en grand détail par la Palestine dans ses interventions d'hier. Israël ne peut imposer aucune mesure spécifiquement interdite par le droit humanitaire international, telle que les déplacements forcés massifs, la destruction de biens, l'installation de colons, le ciblage des écoles et même le ciblage des programmes scolaires pour effacer l'histoire du peuple palestinien. Israël ne peut faire subir ces punitions collectives à la population tout en bombardant à grande échelle et sans discernement des civils et des biens de caractère civil, des actes qui constituent manifestement des violations de ses obligations en tant que puissance occupante. Troisièmement, dans le cadre de son devoir d'assurer l'ordre public, la vie et la sécurité des civils, Israël doit agir d'une manière conforme à ses obligations en vertu du droit international humanitaire et du droit international des droits de l'homme, qui donne la priorité au bien-être de la population palestinienne. Il s'agit notamment de ne pas empêcher, entraver ou restreindre les programmes de secours collectifs qu'Israël doit accepter et faciliter dans toute la mesure de ses moyens, sans réserve. Cela inclut le respect des privilèges et immunités de l'Organisation des Nations Unies, qui entreprend de tels programmes d'aide en même temps que l'entrée dans le territoire palestinien occupé et la circulation dans ce territoire. Toute dissolution des institutions quasi-étatiques de la Palestine, y compris celles administrées par l'UNRWA depuis 1949, risquerait d'entraîner l'effondrement complet de l'ordre public et de la vie civile et constituer un acte clairement destiné à détruire la viabilité de l'État palestinien. Cela ciblerait des parties intégrantes du système palestinien de logement, d'éducation et de soins de santé, La dissolution de ces institutions est interdite en vertu de l'article 47 de la 4e Convention de Genève. Dans le cadre de son obligation de mettre fin le plus rapidement possible à sa présence illégale dans le territoire palestinien occupé, Israël doit mettre fin à son administration illégale de la circulation et de l'entrée dans le territoire palestinien occupé en vertu du jus ad bellum. Monsieur le Président, Mesdames et Messieurs de la Cour, plusieurs États dans leurs exposés écrits ont souligné les obligations de faire d'Israël en vertu de la 4e Convention de Genève. Israël demeure responsable au premier chef de l'exécution des obligations qui lui incombent en vertu des dispositions de cette Convention. Aucune exception ni réserve n'est prévue dans ces dispositions. L'article 69 du premier protocole additionnel élargit la nature des biens qui doivent être fournis compte tenu des conditions locales. Ces obligations inconditionnelles comprennent une obligation faite à Israël de ne pas entraver l'entrée et la liberté de circulation du personnel humanitaire de secours dans le territoire palestinien occupé. La puissance occupante ne peut pas non plus refuser d'accepter et de faciliter le transit rapide de l'aide humanitaire par son territoire lorsqu'il s'agit de matériel de secours et de personnel essentiel à la survie des civils. La résolution 2720 de 2023 du Conseil de sécurité exigeait la pleine mise en œuvre de la résolution 2712 de 2023 qui demandait l'acheminement, je cite, notamment d'eau, d'électricité, de combustible, de nourriture et de fournitures médicales, ainsi que des réparations d'urgence aux infrastructures essentielles. Fin de citation. Elle exigeait également que toutes les parties s'acquittent des obligations que leur impose le droit international, y compris le droit international humanitaire, et demandait de permettre un accès complet pour les agences humanitaires des Nations Unies et leurs partenaires d'exécution. Les ordonnances de cette Cour des 26 janvier, 28 mars et 24 mai 2024 constituent des obligations juridiques supplémentaires pour Israël d'accepter et de faciliter le passage sans entrave de l'aide humanitaire vers la bande de Gaza, je cite, en pleine coopération avec les Nations Unies. Fin de citation. Cependant, Israël ignore de manière flagrante ces obligations contraignantes. Au contraire, 1 mois et demi après l'entrée en vigueur de sa loi interdisant l'UNRWA, Israël a redoublé ses privations d'aide en imposant un blocus de près de 8 semaines à Gaza. L'Afrique du Sud a publié 2 dossiers publics qui exposent en détail, entre autres, le déni par Israël de la politique d'aide. L'UNRWA ne commet pas un, je cite de leur exposé écrit, plaidoyer politisé unilatéral, mais agit plutôt conformément aux obligations que lui a reconnues l'Assemblée générale des Nations Unies en tant que, je cite, défenseur mondial de la protection et de la prise en charge des réfugiés palestiniens. Fin de citation. Ainsi que des obligations coutumières de l'ONU de ne pas reconnaître comme légale la présence illégale de l'État d'Israël dans le territoire palestinien occupé. Les allégations d'Israël sont calculées et délibérées dans un contexte où Israël a imposé une interdiction générale à toutes les organisations humanitaires et à l'acheminement de l'aide humanitaire à Gaza par des États tiers. Cela inclut de nouvelles procédures restrictives visant à bloquer davantage toute organisation humanitaire opérant dans le territoire palestinien occupé. Monsieur le Président, Mesdames et Messieurs de la Cour, l'Afrique du Sud fait valoir que le peuple du territoire occupé y maintient toujours sa souveraineté. Le peuple de Palestine, par l'intermédiaire de ses représentants désignés, a consenti à recevoir de l'aide humanitaire ainsi qu'à la présence et aux activités de l'ONU et d'États tiers dans le territoire palestinien occupé. Le droit de l'occupation, et en particulier les articles 59 à 61 de la 4e Convention de Genève, n'exige pas le consentement d'une puissance occupante dans le cas où la population civile n'est pas suffisamment approvisionné. C'est donc le droit de l'occupation, et en particulier les articles 55 à 61 de la 4e Convention de Genève, qui sont applicables au territoire palestinien occupé, imposant à Israël non seulement de, je cite, « permettre », mais, je cite encore, « d'assurer la fourniture d'aide et de services de base ». En outre, l'article 11 de la 4e Convention de Genève envisage clairement un rôle pour les organisations humanitaires en tant que substitut des puissances protectrices de la population civile protégée. Les Nations unies ont continué à jouer un rôle de protection du peuple palestinien qui s'était vu garantir une pleine autodétermination avec le statut de mandat de classe A et qui a ensuite été dépossédé de son territoire et déplacé de force durant la Nakba en 1948. Ce qui a nécessité la création de l'UNRWA pour garantir les droits des Palestiniens réfugiés, y compris les droits de plus de 70% des Palestiniens de Gaza, qui sont systématiquement privés de leur droit au retour dans leur foyer. Dans le cadre de son occupation illégale, Israël ne se soucie pas de s'acquitter de ses obligations en tant que puissance occupante, mais cherche à usurper des droits de manière abusive. Les actions et les omissions d'Israël violent clairement le droit de l'occupation dans son ensemble et l'on ne saurait permettre la persistance de ces graves violations du droit international humanitaire. Monsieur le Président, Mesdames et Messieurs de la Cour, la deuxième partie de la thèse de l'Afrique du Sud est close. Monsieur le Président, permettez-moi de vous demander d'inviter Monsieur Jamian Hendricks, conseiller juridique de l'État en droit international, à présenter à la Cour les conclusions de l'Afrique du Sud.
Madame Gillet, I now invite Mr. Jamian Hendricks to address the court. You have the floor, sir.
Mr. President, members of the court, it is an honor to appear before you on behalf of the Republic of South Africa. International law prohibits Israel from the use of starvation as a method of warfare, including under siege or blockade. Israel may not collectively punish the protected Palestinian population, which it holds under unlawful occupation. The UN Special Rapporteur on the Right to Food, in his report of 17 July 2024, stated, "Starvation reflects a state's fundamental abandonment of its human rights obligations," and further, that the State of Israel has deployed the full range of techniques of hunger and starvation, perfecting the degree of control, suffering and death that it can cause through food systems, leading to this moment of genocide. Despite the horrific attempts by Israeli officials to characterize them otherwise, Palestinians are human beings. They are flesh and blood. Palestinian people are entitled to the same fundamental protections as we in this great hall of justice. And this includes the right not to be arbitrarily deprived of life, the supreme right from which no derogation is permitted, even in situations of armed conflict. Israel's humanitarian blockade, including its ban of UNRWA, renders the Palestinian population significantly less resilient to Israel's acquisition of territory by force and of its genocide. In so doing, Israel is breaching the right to self-determination of the Palestinian people, a peremptory norm of international law enshrined in the UN Charter and Common Article 1 of the International Covenants on Human Rights. Furthermore, Israel is impeding the United Nations and third states from exercising their erga omnes obligations and international solidarity with respect to the exercise of the fundamental human rights of the Palestinian people, which this court held to include the right to self-determination. In relation to Israel's obligations towards the United Nations, the 1946 General Convention provides for no exceptions to the inviolability of the United Nations, which applies equally in times of peace and in armed conflict. States are under a legal obligation to protect the inviolability of all UN premises and property, wherever located and by whomever held. Israel must therefore cooperate in good faith with the United Nations and render it every assistance. And despite its abrogation of its bilateral and operational agreement with UNRWA, Israel's obligations under the UN Charter and the General Convention prevail. Mr. President, members of the Court, turning now to the legal consequences which flow from the question before the Court. South Africa submits that Israel's unlawful occupation and its aforementioned violations of peremptory norms of international law constitute internationally wrongful acts attributable to the State of Israel. This necessarily invokes the law of state responsibility. Israel must therefore immediately cease its internationally wrongful acts and make reparation in full, including through restitution, compensation, and satisfaction. Israel must comply with its obligations as an occupying power to ensure food and medical supplies and facilitate the unhindered provision of humanitarian goods, essential services, and development assistance by the UN, third states, and other international organizations. It must fully cease hostilities to ensure their ability to deliver assistance. Israel must comply with this court's binding provisional measures in South Africa versus Israel and take effective measures to ensure, without delay and in full cooperation with the United Nations, the unhindered provision at scale and by all concerned of urgently needed basic services and humanitarian assistance to Palestinians in Gaza. Finally, Israel must immediately reverse its decision to expel UNRWA and other UN bodies from carrying out their mandated activities. Turning to the obligations on the United Nations, the United Nations and its bodies are under a duty not to recognize Israel's internationally wrongful acts, such as its unlawful eviction of UNRWA and its unlawful powers reserved for the legitimate sovereign in Palestine. And despite Israeli restrictions, the UN and its agencies, including UNRWA, must continue to render humanitarian assistance to the Palestinian people. It must demand and negotiate for the removal of barriers imposed by Israel. Turning to the obligations on third states. Third states have an obligation not to recognize as lawful Israel's internationally wrongful acts, including its banning of UNRWA, not to maintain these acts and to collaborate to bring such acts to an end. It is imperative that third states refrain from providing arms which enable Israel's continued breaches of international law in the occupied Palestinian territory. Mr. President, members of the Court, in conclusion, South Africa shares the UN Secretary General's view that the world has failed the Palestinian people. The only certainty they have is that tomorrow will be worse. Therefore, we must save whatever is left of our humanity by ending Israel's unlawful settler colonial occupation and its intentional starving of the Palestinian population, who are being systematically brutalized and deprived of the most elementary considerations of humanity. Palestinians look to the world and to this court for an end to their enduring loss, their pain, and their suffering. Mr. President, members of the court, this brings to an end South Africa's oral submission. I wish to thank the court for your attention.
I thank the representatives of South Africa for their presentation. J'invite à présent la délégation de l'Algérie à prendre la parole et appelle à la barre Madame Maya Salih Fadel.
Monsieur le Président, Mesdames et Messieurs membres de la Cour. Monsieur le Président, permettez-moi tout d'abord, au nom de mon pays, l'Algérie, et de la délégation qui m'accompagne, de vous féliciter pour votre accession à la présidence de cette auguste institution. C'est un privilège également pour moi de m'adresser devant vous au nom de mon pays et de présenter l'exposé oral dans le cadre de la procédure consultative relative à la requête de l'Assemblée générale des Nations unies du 19 décembre 2024. Je commencerai tout d'abord par quelques propos introductifs et factuels. Monsieur le Président, Mesdames et Messieurs membres de la Cour, sans revenir sur tous les éléments factuels qui ont déjà fait l'objet de larges développements dans les différentes mémoires écrits soumis à la présente Cour, l'Algérie tient à rappeler que près de 6 millions de réfugiés palestiniens sont enregistrés auprès de l'UNRWA. L'agence gère 58 camps de réfugiés et 711 écoles fréquentées par 550 000 élèves. L'UNRWA gère 141 centres de soins de santé primaire. Elle fournit également un filet de sécurité sociale à près de 332 763 personnes, en plus d'un enseignement et une formation technique et professionnelle à 7 811 jeunes et a alloué des prêts de microfinance à 27 199 clients. Depuis le 2 mars 2025, un blocus délibéré, décidé par l'occupant israélien, empêche l'acheminement de toute aide alimentaire à Gaza, laissant une population palestinienne confrontée à la faim et au manque de moyens de subsistance de première nécessité. Comme l'a souligné le commissaire général de l'UNRWA, nous assistons, j'insiste, à une famine provoquée par l'homme et motivée par des considérations politiques. Le récent massacre de 15 secouristes et ambulanciers palestiniens, dont les corps ont été retrouvés dans une fosse commune, a déclenché une indignation mondiale. Mais tout en passant sous silence de nombreuses attaques perpétrées contre des femmes et des enfants dans le territoire palestinien occupé. L'Algérie rappelle que la situation désespérée à Gaza et le blocus de l'aide humanitaire sont aujourd'hui utilisés comme monnaie d'échange et armes de guerre. Le comportement d'Israël à l'égard de l'UNRWA est bien antérieur à l'offensive débutée à Gaza depuis octobre 2023. Néanmoins, les attaques perpétrées depuis restent sans précédent. Israël a attaqué le personnel et détruit les locaux, les biens et les installations appartenant à l'UNRWA. A pris pour cible également et tué et détenu le personnel de cette agence. Ces éléments démontrent qu'Israël mène depuis longtemps une politique visant à entraver le mandat originel de l'UNRWA. L'adoption des 2 lois israéliennes du 28 octobre 2024 perpétue encore les entraves déjà mentionnées. Un tel comportement est incompatible avec les obligations d'Israël en tant que puissance occupante et membre des Nations unies, et se trouve en totale contradiction avec les règles énoncées dans la Convention des Nations unies sur les privilèges et immunités. D'un point de vue juridique, l'UNRWA a un mandat unique qui concerne les aspects essentiels de la question palestinienne, notamment le droit au retour des réfugiés palestiniens et le droit inaliénable du peuple palestinien à l'autodétermination. Par ailleurs, l'Algérie tient à rappeler qu'Israël est tenu de respecter les privilèges et immunités auxquels l'UNRWA a droit, notamment l'immunité de juridiction et l'inviolabilité de ses locaux, de ses biens, de ses fonds, de ses installations et de ses équipements. Les privilèges et immunités de l'UNRWA sont absolus et ne peuvent être limités, restreints ou écartés pour des raisons telles que la conduite d'hostilité. Je m'en vais développer la thèse de l'Algérie autour de 4 points. Le premier point consistera bien sûr, après ces propos introductifs, à analyser les obligations d'Israël en tant que membre des Nations Unies et puissance occupante. Troisième point concernera l'analyse de l'illégalité des lois israéliennes du 28 octobre 2024. Le quatrième point portera sur les violations par Israël de ses obligations et la mise en œuvre de sa responsabilité internationale. En ce qui concerne les obligations d'Israël, membre des Nations Unies et puissance occupante, évoquer la question relative aux obligations d'Israël doit nous conduire de prime abord à analyser ces obligations sous l'angle du droit international public général, reflété dans la Charte des Nations Unies, les conventions internationales pertinentes et les résolutions à la fois de l'Assemblée générale et du Conseil de sécurité. S'agissant de la lex specialis, ces obligations doivent être identifiées dans le corpus du droit international humanitaire et du droit international des droits de l'homme. Sans revenir sur les éléments factuels ayant fait l'objet de développements précédents, il paraît incontestable pour l'Algérie qu'Israël, en tant que membre des Nations Unies, mais aussi en tant que puissance occupante, ne pourrait prétendre à des marges d'appréciation illimitées pour interdire les activités de l'ONU, de ses différents organes et organismes, dont l'UNRWA. L'obligation d'Israël de coopérer de bonne foi avec l'ONU, telle qu'elle découle de la Charte, est rappelée par la Cour dans son ordonnance en indication de mesures conservatoires du 28 mars 2024, affaire opposant l'Afrique du Sud à Israël, selon laquelle Israël, je cite, doit prendre toutes les mesures nécessaires et effectives pour veiller sans délai, en étroite coopération avec l'Organisation des Nations Unies, à ce que soit assurée, sans restriction et à grande échelle, la fourniture par toutes les parties intéressées des services de base et de l'aide humanitaire requis de toute urgence. En conséquence, l'Algérie soutient que, sur la base de son obligation de respecter les principes erga omnes et notamment le droit du peuple palestinien à l'autodétermination, Israël est dans l'obligation de ne pas empêcher, d'entraver ou de restreindre de toute autre manière la présence et les activités de l'UNRWA dans les territoires occupés, y compris Jérusalem-Est. Nous aborderons ces différentes obligations autour de 3 points. Tout d'abord, les obligations d'Israël en tant que membre des Nations Unies, conformément à la Charte et aux autres textes pertinents. Les articles 2, paragraphes 5, 100, 103, 104 et 105 de la Charte des Nations Unies constituent le fondement des obligations d'Israël en ce qui concerne la présence et les activités de l'ONU, ses organes, dont l'UNRWA, les autres organisations et les États tiers dans le territoire palestinien occupé, y compris Jérusalem-Est. Ces obligations comprennent le devoir de coopérer et de faciliter leurs activités ainsi que le devoir de respecter les privilèges et immunités auxquels ils doivent prétendre, tout en rappelant par là même qu'Israël est partie à la Convention sur les privilèges et immunités des Nations Unies et que le champ d'application de cette Convention a été explicitement étendu au territoire palestinien occupé par l'accord conclu entre Israël et l'UNRWA en 1967. Comme l'a rappelé le secrétaire général de l'ONU dans sa lettre du 9 décembre 2024 sur les obligations d'Israël au titre de l'article 2, paragraphe 5 de la Charte, en ce qui concerne l'UNRWA, je cite, « En tant que membre des Nations Unies, Israël continue d'être tenu, conformément à l'article 2, paragraphe 5 de la Charte des Nations Unies, d'apporter à l'UNRWA toute l'assistance possible dans toute action qu'il entreprend, conformément aux décisions pertinentes des organes principaux compétents adoptées en vertu des dispositions de la Charte.
I'm sorry to interrupt you, but could you please speak more slowly to facilitate the work of the interpreter?
Yes.
Thank you very much.
En vertu des dispositions de la Charte y compris la résolution 302-4 de l'Assemblée générale et les résolutions ultérieures de l'Assemblée générale renouvelant le mandat de l'UNRWA. Aussi, les dispositions des articles 100 et 104 de la Charte des Nations unies complètent les articles 2, alinéas 5 et 105. Ces dispositions protègent ce que la Cour a appelé l'action indépendante de l'organisation. C'est ainsi qu'en vertu des articles 2, paragraphe 5, 100 et 104 de la Charte des Nations unies, Israël est tenu de faciliter les opérations de l'UNRWA dans le territoire palestinien occupé, y compris Jérusalem-Est. J'en viens maintenant au deuxième point, les obligations d'Israël en tant que puissance occupante. L'un des éléments de la question soumise à la Cour par l'Assemblée générale, dans sa résolution 79/232, concerne les obligations d'Israël en tant que puissance occupante, notamment d'assurer et de faciliter sans entrave les fournitures indispensables à la survie de la population civile dans le territoire occupé, conformément au droit international humanitaire et au droit international des droits de l'homme. L'applicabilité du droit international humanitaire, tant conventionnel que coutumier, au territoire palestinien occupé est incontestable et revêt une importance primordiale. C'est sur la base de l'article 43 du règlement de La Haye, qui constitue le point de départ des obligations d'Israël en tant que puissance occupante et qui permet d'assurer et de faciliter sans entrave l'acheminement des fournitures indispensables à la survie de la population palestinienne, les services de base, l'aide humanitaire et le développement au profit de la population palestinienne. Ces obligations sont à la charge d'Israël. L'Algérie considère qu'Israël a l'obligation de respecter et faire respecter les conventions de Genève en toutes circonstances. Comme la Cour l'a précisé, je cite, « Une telle obligation ne découle pas seulement des conventions elles-mêmes, mais des principes généraux du droit humanitaire dont les conventions ne sont que l'expression concrète. » L'obligation fondamentale, consacrée dans l'article 59 de la 4e Convention de Genève, relatif au secours collectif, ne saurait permettre à Israël de s'y soustraire dès lors qu'il est établi que la population du territoire occupé est insuffisamment approvisionnée, tel que rappelé par les organes des Nations unies et corroboré par le Comité international de la Croix-Rouge, le CICR, qui précise que cette obligation de la puissance occupante d'accepter des secours collectifs a un caractère inconditionnel. Elle complète de même celle établie à l'article 55 de la dite Convention relative au ravitaillement des populations. Si Israël, puissance occupante, dispose d'une certaine marge d'appréciation dans l'acceptation et la facilitation de l'aide humanitaire, notamment dans le choix des acteurs humanitaires, il est fondamental, compte tenu de l'article 59 de la 4e Convention, qu'il tienne compte des besoins concrets de la population du territoire palestinien occupé et des possibilités opérationnelles qui permettent de pourvoir à une aide effective. Au vu de la situation humanitaire désastreuse dans la bande de Gaza et le fait que l'UNRWA soit le principal pourvoyeur d'aide humanitaire et de services essentiels dans le territoire palestinien occupé, réduit significativement les marges d'appréciation dont dispose Israël dans l'exécution de cette obligation. Monsieur le Président, l'Algérie considère qu'Israël, en tant que puissance occupante, est tenu, tant que cette situation perdure, d'accorder l'accès humanitaire à l'UNRWA et de tout mettre en œuvre pour faciliter ses activités de secours dans le territoire palestinien occupé. L'Algérie constate avec désarroi que la situation dans les territoires palestiniens, et en particulier à Gaza, est l'un des pires échecs humanitaires de notre génération. Chaque personne à Gaza dépend de l'aide humanitaire pour survivre. Ce lien vital a été totalement rompu depuis qu'un blocus total sur l'aide a été imposé par les autorités israéliennes le 2 mars de l'année en cours. Nous vivons un moment de crise sans précédent, consécutif éventuellement d'un effondrement humanitaire. Outre les violations du droit international humanitaire, les pratiques israéliennes qui entravent la présence et les activités des Nations Unies, d'autres organisations internationales et d'États tiers dans le territoire palestinien occupé, ainsi que la fourniture de l'aide et de l'assistance, s'inscrivent beaucoup plus dans une politique israélienne visant à perpétuer sa présence illégale dans le territoire palestinien occupé et à participer de manière progressive à l'expulsion, au transfert, au déplacement forcé du peuple palestinien hors du territoire palestinien occupé et à légitimer l'expulsion d'une agence de l'ONU, l'UNRWA, tout en accentuant la souffrance des Palestiniens en l'absence de services essentiels. L'aide humanitaire ne doit jamais être utilisée comme un outil politique ou une arme de guerre. Sauver des vies ne devrait jamais être un sujet de controverse. Les principes et règles du droit international développés au fil des siècles pour protéger les civils ne doivent pas être balayés et l'impunité ne doit pas perturber. Seul le droit de l'occupation doit encore s'appliquer. Troisième point de ma présentation, analyser Israël face au droit à l'autodétermination du peuple palestinien. La Cour a affirmé à plusieurs reprises que le droit à l'autodétermination constitue l'un des principes essentiels du droit international contemporain et que l'obligation de respecter ce droit étant un principe erga omnes, tous les États ont un intérêt juridique à ce qu'il soit protégé. La Cour a considéré dans son avis du 19 juillet 2024 que, je cite, « la dépendance de la Cisjordanie, de Jérusalem-Est et en particulier de Gaza à l'égard d'Israël pour la fourniture des biens et services essentiels compromet la jouissance des droits fondamentaux, notamment du droit à l'autodétermination. » L'Algérie rappelle les résolutions adoptées par l'Assemblée générale qui ont reconnu le droit du peuple palestinien à l'autodétermination, y compris son droit de créer son propre État indépendant, et ont énoncé un certain nombre d'obligations à l'égard d'Israël. La création de l'UNRWA participe à la réalisation des droits inaliénables du peuple palestinien. Aux fins de la présente procédure, l'obligation de respecter le droit du peuple palestinien à l'autodétermination emporte pour Israël l'obligation de coopérer afin de permettre la réalisation de ce droit au profit du peuple palestinien, d'assurer de faciliter l'aide et l'assistance humanitaire, de veiller également à ce que cette aide participe au développement, puisse se poursuivre et constituer un véritable impératif humanitaire. Cependant, ce droit inaliénable, principe de jus cogens, se heurte à un déni perpétuel d'Israël. Pour rappel, le 18 juillet 2024, la veille du prononcé par cette même Cour de l'avis consultatif de juillet 2024, la Knesset a adopté une déclaration s'opposant à la création d'un État palestinien. Déclaration qui, une fois de plus, est en violation flagrante du droit du peuple palestinien à l'autodétermination. Monsieur le Président, avant de terminer mes propos et de passer la parole à la professeure Samia Bourouba, nous tenons à souligner, au vu des violations commises par Israël, que nous assistons à une absence de réaction effective de la communauté internationale, malgré les appels constants du secrétaire général de l'ONU, du commissaire général de l'UNRWA, des acteurs humanitaires, de certains États tiers. Nous assistons à une absence d'action de la communauté internationale et à une présence d'une communauté d'intérêts au détriment du peuple palestinien, de ses droits les plus élémentaires, de son existence, de son devenir et de son avenir. Annéler l'UNRWA revient aujourd'hui à annéler le droit du peuple palestinien à exister, à survivre, à retourner sur ses terres. L'interdiction de l'UNRWA par Israël est une manière de détruire le présent et l'avenir du peuple palestinien. Abandonner cette agence, c'est abandonner le peuple palestinien et consacrer une politique de deux poids deux mesures au mépris du droit international, des décisions de cette haute cour, de la légalité internationale et des principes d'égalité et de justice consacrés par la Charte des Nations Unies, dont je rappelle que le contenu a été finalisé il y a de cela 80 ans, le 26 avril 1945, et nous sommes le 29 avril 2025. Permettez-moi, Monsieur le Président, à la suite de la conclusion de mes propos, d'inviter et de donner la parole au professeur Samia Bourouba pour la suite de l'exposé oral de l'Algérie. Je vous remercie.
Je remercie Madame Salih Fadel. Je donne maintenant la parole à Madame Samia Bourouba. Madame, je vous en prie.
Monsieur le Président, Mesdames et Messieurs les membres de la Cour, consacrer la troisième partie de cet exposé oral à l'illégalité des deux lois israéliennes du 28 octobre 2024 constitue pour l'Algérie la manifestation la plus claire du non-respect par Israël de ses obligations internationales. Les attaques contre les locaux et le personnel de l'UNRWA et les obstructions faites à leur action humanitaire n'ayant à l'évidence pas suffi, Israël en est revenu à sa pratique habituelle, celle de légiférer contre le droit international. De brèves observations sur les deux lois israéliennes s'imposent. Elles se rapporteront à la forme et au fond. Quant à la forme, l'intitulé des deux lois adoptées le même jour est édifiant. Il porte en lui-même leur caractère illégal. Je rappelle que la première a pour intitulé, je cite, « Cessation des activités de l'UNRWA ». Fin de citation. Et la seconde porte l'intitulé, je cite, « Cessation des activités de l'UNRWA dans Israël ». Fin de citation. Ces intitulés, pris dans leurs lettres et leur esprit, renseignent à première vue sur l'intention d'Israël de mettre fin à la présence et aux activités de l'agence établie par l'Assemblée générale des Nations unies et d'élargir son application dans le territoire palestinien occupé. L'autre fait qui interpelle est l'intitulé de la seconde loi, qui confirme l'obsession d'Israël d'occuper, voire d'annexer, Jérusalem-Est, faisant fi de sa condamnation dans les avis consultatifs de 2004 et 2024, ainsi que dans les résolutions du Conseil de sécurité et de l'Assemblée générale. L'entrée en vigueur des deux lois, le 30 janvier 2025, démontre que l'urgence est là pour Israël, non celle découlant de l'obligation de faire cesser la détresse du peuple palestinien, aggravée par des mois de privation de ses besoins les plus élémentaires, mais pour achever l'entreprise engagée depuis la dernière opération militaire de mettre fin à la présence et aux activités de l'agence, principale organisation mise sur pied par l'ONU au lendemain de la Nakba, pour assister les réfugiés palestiniens privés de leurs terres, biens et droits les plus élémentaires, dont leur droit au retour et à l'édification d'un État palestinien. Quant au fond, le premier élément qui renseigne sur la non-conformité des deux lois aux obligations d'Israël du point de vue de l'Algérie est le fait de faire primer les mesures prises par un acte unilatéral sur des obligations internationales librement consenties. Mesures contenues dans respectivement l'article 1er qui prononce la fin de l'échange de lettres de 67, l'article 2 qui interdit à toutes les autorités israéliennes tout contact avec l'agence et l'article 3 qui prévoit que cette loi n'exclut pas les poursuites pénales contre les employés de l'Office. Je passerai au second point de cette troisième partie, conséquences juridiques de la mise en œuvre des deux lois dans le territoire palestinien occupé. Il s'agit d'envisager cette application dans les trois parties qui constituent le territoire palestinien occupé, ce qui permettra de mettre le point sur le non-respect par Israël, membre des Nations unies et puissance occupante de ses obligations. Dans la bande de Gaza d'abord, l'Algérie met un accent particulier sur les répercussions humanitaires de la mise en œuvre des lois israéliennes au regard de la situation de cette partie du territoire occupés par Israël et quartier général de l'UNRWA. Sans trop tarder, on peut aisément mesurer les effets de l'interdiction de l'UNRWA, privation de la population gazaoui de toute aide concernant les produits de première nécessité et des services de base. À Jérusalem-Est, en date du 8 avril courant, selon le rapport de l'UNRWA, des fonctionnaires israéliens de l'éducation de la municipalité de Jérusalem, accompagnés de forces israéliennes, sont entrés en force dans 6 écoles de l'agence, munies d'ordres de fermeture, qui prendront effet dans les 30 jours suivants, soit le 8 mai prochain. Cette fermeture, qui entraînera la privation de la scolarisation de 800 élèves, constitue pour Israël une violation de ses obligations de respecter l'inviolabilité des locaux des organisations internationales. En Cisjordanie, l'effet des lois touchera principalement l'interdiction qui vont mettre à mort le droit à l'éducation et le droit à la santé. Pour l'Algérie, les 2 lois israéliennes, qui sont ipso facto frappées de nullité, ne pourraient mettre fin de manière unilatérale aux obligations d'Israël, telles qu'elles résultent de l'échange de lettres de 1967. Dans la note verbale datée du 8 janvier 2025, adressée par le secrétaire général des Nations Unies, je cite, « Israël demeure tenu d'accorder à l'UNRWA tous les privilèges, immunités et facilités prévus par la présente Convention générale et confirmés dans l'échange de lettres tant que l'UNRWA opère dans le territoire palestinien occupé, y compris Jérusalem-Est. » La 4e partie de cet exposé va étaler brièvement les violations par Israël de ses obligations et la mise en œuvre de sa responsabilité internationale. Les violations peuvent être regroupées en 3 catégories. D'abord, des violations de l'obligation de fournir les articles de première nécessité et des services de base. L'Algérie tient à rappeler les différentes violations israéliennes, dont la décision du 2 mars de l'année en cours, et alors que le cessez-le-feu est en vigueur, de suspendre toute entrée de marchandises et d'approvisionnement dans la bande de Gaza, privée à cet effet de nourriture, d'eau potable, d'abris et de soins médicaux. Ensuite, les violations de l'obligation de fournir l'aide humanitaire et l'aide au développement. À cause des restrictions imposées par Israël déjà citées, ayant entraîné une baisse spectaculaire de l'aide humanitaire, à travers plusieurs résolutions, notamment la résolution 2730 de 2024, le Conseil de sécurité a mis l'accent sur les violations dites. Concernant l'aide au développement maintenant, il va sans dire pour l'Algérie que les entraves israéliennes à la fourniture des articles de première nécessité et à l'acheminement de l'aide humanitaire ont très gravement contribué à la détérioration de la situation sociale et économique déjà précaire du peuple palestinien. La déclaration de l'administrateur du PNUD résume l'appauvrissement de la population palestinienne. Je cite, « Les projections de cette nouvelle évaluation confirment qu'au milieu des souffrances immédiates et des horribles pertes en vies humaines, une grave crise de développement est en train de se produire. Une crise qui compromet l'avenir des Palestiniens pour des générations à venir. » Fin de citation. L'Algérie n'ajoutera pas plus. Le dernier point, enfin, c'est les violations du droit du peuple palestinien à l'autodétermination, un droit bien étalé par les différents propos. Je m'attellerai juste à considérer que les violations par Israël de ses obligations à l'égard de la présence et des activités des Nations Unies et de toutes les organisations compromettent ce droit absolu. Si tous les chemins mènent à Rome, il n'y a qu'un seul chemin qui doit mener le peuple palestinien vers sa dignité. C'est celui de son droit à l'autodétermination. 4e sous-point, c'est le fait d'engager la responsabilité internationale d'Israël du fait de ces violations. Elle se fonde sur les différents articles contenus dans les articles de la Commission du droit international relatifs à la responsabilité internationale de l'État pour faits internationalement illicites, qui sont imputables à Israël du fait des différentes violations. Je citerai juste la responsabilité internationale d'Israël qui est engagée en vertu de l'article 41 concernant la violation grave de la règle du jus cogens qu'est le droit du peuple palestinien à l'autodétermination. Pour conclure, l'Algérie réitère les demandes exprimées dans son exposé écrit et prie la Cour de déclarer qu'Israël viole ses obligations juridiques en tant que membre de l'ONU à l'égard de l'organisation et en tant que puissance occupante. Monsieur le Président, Mesdames et Messieurs les membres de la Cour, je vous remercie pour votre attention.
Je remercie les représentants de l'Algérie pour leur présentation. I now invite the delegation of Saudi Arabia to make its oral statement, and I call upon Mr. Mohammed Saud Al-Nassar to take the floor. You have the floor, sir.
Mr. President, distinguished members of the Court, it's an honor for me to appear before you to present my country's views on a matter of a critical importance for the United Nations, all states, and in particular for the Palestinian people. Mr. President, on behalf of my country, the Kingdom of Saudi Arabia, I would like first to congratulate you on assuming the presidency of this court. Mr. President, distinguished members of the court, less than a year ago, the court held that Israel's policies and practices in the occupied Palestinian territory, including its settlement practice, its continuing occupation, and its annexation of parts of that territory are flagrant violations of international law that must be brought to an end as a matter of urgency. The court's ruling marked a clear path for Israel to follow in finally bringing itself into international legality. Sadly, but predictably, Israel chose to ignore the court's ruling, showing that it considers itself above the law. Outrage over Israel's conduct, particularly since October 2023, has compelled the UN General Assembly to return to the court to seek its guidance on another pressing matter. This time, the question placed before the court and the circumstances which have brought it about are of more immediate and extreme importance. Those circumstances include the General Assembly's alarm over the impunity with which Israel has continuously blockaded the provision of humanitarian, life-saving, and other desperately needed assistance by the UN and other concerned parties to the Palestinian population throughout the occupied Palestinian territory, most egregiously in the Gaza Strip. Confirming the obligations of Israel to allow the United Nations, other international organizations, and third states to carry out activities in the occupied Palestinian territory, including providing such assistance, could truly make the difference between life and death for many people. Israel's hideous conduct, which piles illegality upon illegality, is well documented. Its most ruthless application has been the siege conditions imposed over the Gaza Strip since October 2023. As the entire world is painfully aware, diseases, lack of sanitation, clean water, food, shelter, and medical care is endemic. While temporary respites have occasionally occurred, Israel has reimposed conditions of total blockade at will, just as it did in early March this year, completely halting the provision of food, water, medical supplies, temporary housing, fuel, and anything else to the starving, displaced, and exposed population of the Gaza Strip. Nothing justifies such barbarity. Israel's blockade of humanitarian assistance and simultaneous brutalization of the civilian population throughout bombardment can only be understood as two components of a single enterprise, namely a means for bringing about the ethnic cleansing of the Gaza Strip, displacing or killing its Palestinian population to make room for Israel to settle and annex the territory. Israel's failure to ensure and facilitate unhindered humanitarian assistance to the population of Gaza would surely be seen as an integral part of this crime against humanity, if it were ever to come to pass. And of course, withholding such a humanitarian development assistance also plays a role in a larger Israeli undertaking, that is, to demolish the established right of the Palestinian people to self-determination by undermining their ability to survive and stand on their own. The court is aware of the appalling circumstances faced by the population of the Gaza Strip and their dire need for humanitarian assistance on a sustained basis. The court has issued provisional measures in South Africa versus Israel on 3 occasions, ordering Israel to take all necessary and effective measures to ensure the provision of desperately needed humanitarian assistance to Palestinians throughout Gaza. Israel ignored those orders, as it has similar calls made by other UN bodies, international organizations, and concerned states. Instead, it has exacerbated the humanitarian crisis and turned the Gaza Strip into an unlivable pile of rubble, while killing thousands of innocent and vulnerable people. Mr. President, distinguished members of the court, on or around April 15th of this year, the Palestinian death toll in the Gaza Strip reached a grim figure of 51,000, some 15,000 of them children. Over 116,000 people have been wounded. These figures increase every day, even during the short periods of so-called ceasefire. It's not difficult to understand why, as the Israeli military has removed all restraints on killing innocents. It has conducted over 40,000 airstrikes on the tiny strip. Terrifyingly, it employs artificial intelligence to determine who to kill and who to spare. Establishes kill zones where anyone crossing invisible boundaries, even women and children, is shot on sight. Bombards so-called safe zones, killing countless innocents, many while sheltering in flimsy tents. And denies requests by international organizations to import equipment required to clear the estimated thousands of unexploded Israeli ordnance scattered across the Gaza Strip, which have killed or maimed numerous innocent Palestinians. Adding to these catastrophic conditions has been the systematic destruction of hospitals, water infrastructure, agricultural land, bakeries, homes, and other vestiges of life throughout the territory, creating conditions of suffering, disease, and starvation. The request now before the court seeking to clarify the obligations of Israel to allow international organizations and states to provide humanitarian assistance and operate within the occupied Palestinian territory, including Gaza, must be seen in this context, as it explains why the request has such urgency and importance. As shameful as Israel's conduct towards the Palestinian people is, the harm it caused them, not the only damaging consequences of that conduct, nor the only reason why the question before the court has such importance. Another critical reason to establish the scope of the Israeli obligations encompassed by the General Assembly's request is to clarify the legal framework for evaluating Israel's actions against the UN and other international organizations and third states seeking to assist the Palestinians within the occupied Palestinian territory. Israel's hostility towards the UN is too lengthy to summarize here. Its attacks have been particularly aimed at UNRWA, which since 1949 has played an indispensable role in safeguarding the basic rights and living conditions of the Palestinian people who were displaced from their homeland, providing health care, education, food, and other assistance to some 5 million refugees. As emphasized by the UN Secretary General, when it comes to providing humanitarian relief and assistance to the people of Gaza, there is no realistic alternative to UNRWA. Israel's hostility against UNRWA began long before the current crisis. However, since October 2023, its attacks have intensified dramatically. Israeli forces have killed over 200 UNRWA employees, attacked and destroyed their premises, ransacked their warehouses, and denied entry to UNRWA relief supplies. Israeli police have stood by while UNRWA's premises in Jerusalem were attacked and burned by an Israeli mob. Israel also ordered UNRWA to vacate its premises in occupied East Jerusalem and has passed laws prohibiting Israeli authorities from having any contact with UNRWA and preventing UNRWA from operating within Israeli territory, which it illegally claims includes occupied East Jerusalem. The excuses Israel has given to justify its actions, claiming that UNRWA lacks neutrality, promotes biased narratives, and is infiltrated by Hamas, have been addressed by the UN and discredited. Moreover, an independent review led by the former French foreign minister found Israel's allegation to be unsubstantiated and lacking of any credible evidence. The fabrications underlying Israel's action against UNRWA and against the UN more generally cannot be seriously doubted. What those actions establish, however, is the court's opinion about Israel's obligation encompassed with the General Assembly's request is urgently required, not just to prevent further harming the Palestinian people's right to receive humanitarian development support, but also to safeguard the legal foundation in which the UN and other entities conduct humanitarian activities. Turning to the court's jurisdiction, our views and the views of almost every other state participating in these proceedings are in agreement that, given the legal questions raised, the court has jurisdiction to issue the requested advisory opinion, and that there are no compelling reason for it not to do so. On the contrary, given the inhumane conditions to which Israel has subjected to the Palestinian people, most terrifyingly in the Gaza Strip, we respectfully submit that the court is under a duty to issue its opinion so that Israel's obligation to ensure and facilitate the provision of humanitarian assistance by the United Nations, other international organizations, and third states are made clear. Furthermore, the General Assembly's inquiry on Israel's obligation impact matters of widespread importance, including the operations of the UN and other aid agencies, as well as Palestinian rights, a matter of universal concern since the adoption of Resolution 181 in the second session in 1947. The requests also highlight urgent issues, including Israel's legislative ban on UNRWA, military actions impeding humanitarian aid, and threats to the UN privileges and immunity. A small minority of a group and states argue that the court should refrain from issuing this advisory opinion because doing so would require it to undertake a significant factual investigation, which is not appropriate for an advisory opinion, or that the question was formulated in a biased manner. These arguments, which were rejected by the court in the Wall and the Israeli policies and practices cases, would be similarly dismissed for the same reasons articulated in those decisions. The same states argue that the court should decline to give this opinion because it has already addressed the subject of the request in its previous advisory opinions related to the occupied Palestinian territory, or that rendering the occupied would prejudge the ongoing contentious proceedings in South Africa versus Israel. These arguments have no merit. The present request is self-evidently distinct from the prior requests, as the scope and nature of Israel's obligations to ensure and facilitate the provision of humanitarian assistance by the UN, other international organizations, and third states was not expressly addressed by the court in either of those advisory opinions, leaving the court views in that regard unknown. As for the argument that these advisory proceedings would prejudge the outcome of the genocide case, that argument fails for obvious reasons. As for the argument, these advisory proceedings would prejudge. In South Africa versus Israel, the court is called upon to interpret and apply the Genocide Convention and to determine whether Israel's conduct in Gaza engage its international responsibility under that convention. To a significant extent, the answer to that question is whether the requisite intent under Article 2 of the Convention can be attributed to Israel. The answer to the questions raised in these proceedings, which are broadly focused on identifying the obligation of Israel to ensure and facilitate humanitarian and other assistance throughout the occupied Palestinian territory, and do not ask the court to determine Israel's responsibility under the Genocide Convention, and would in no way prejudge that narrow question. Turning to the question before the court, I will highlight only a few key points. First, as an occupying power, Israel is bound by international humanitarian law, in particular the Hague Regulations of 1907 and the Fourth Geneva Convention. Under those norms, and at the bare minimum, Israel must guarantee the basic needs of the population in the occupied Palestinian territory at all times, including the provision of food, water, shelter, and medical supplies. It must allow medical personnel to carry out their duties and must not adopt measures amounting to collective punishment. But Israel's obligations do not end there. Pursuant to Article 59 of the Fourth Geneva Convention, if an occupying power is unwilling or unable to fulfill its duty to provide the whole or part of the population of the occupied territory with essential supplies and services, as obviously the case in Gaza, it has an absolute duty to facilitate such provision by international organizations or third states. These obligations are unconditional and are supplemented by Article 69 of Additional Protocol 1. These obligations are, in the case of Israel, complemented by the duty arising under Security Council resolutions not to obstruct, attack, or impede organizations and states from providing urgently needed humanitarian development assistance to the population in the occupied Palestinian territory. As an occupying power, Israel's international human rights law obligations are also engaged. Under these obligations, Israel must respect, protect, and fulfill the fundamental human rights of the Palestinian people in the occupied Palestinian territory. These include their right to life, to the highest attainable standard of physical and mental health, to an adequate standard of living, to adequate food, clothing, housing, water, and education. The obstruction by Israel of efforts by international organizations, including the United Nations, or by third states to provide basic services and assistance to the Palestinian people under occupation in order for them to enjoy such protected human rights entails a clear violation of Israel's human rights obligations. As a UN member and as a party of the UN Convention on Privileges and Immunities, Israel has further obligations relevant to these advisory proceedings. Under Article 2, subsection 2 and 2, subsection 5 of the UN Charter, Israel must cooperate in good faith with the United Nations, giving it, quote, every assistance in any action taken in accordance with the Charter, end quote. Israel's obligation to provide every assistance in good faith to the United Nations encompasses the principal UN organs as well as other UN subsidiary organs, including UNRWA. As UNRWA's mandate is to provide humanitarian assistance to the Palestinian people, Israel duty-bound to give every assistance to UNRWA in good faith. The attempt by certain states in these proceedings to limit Article 2, subsection 5 as only applying to enforcement action by the Security Council pursuant to Chapter 7 of the Charter is incorrect and contrary to this Court's interpretation of that provision in the Reparations Advisory Opinion. Under Article 25 of the Charter, Israel has also agreed to accept and carry out the decisions of the Security Council. Israel must therefore comply with the Security Council resolution demanding that it give unhindered access to those providing humanitarian assistance to the Palestinian people. Israel also has a duty to guarantee that the UN enjoys the legal capacity necessary for exercise of its functions and fulfillment of its purposes. This duty is enshrined in Article 104 of the Charter and Article 1, Section 1 of the Convention on Privileges and Immunities. Moreover, Israel is under a duty to guarantee the United Nations and its officials the privileges and immunities necessary for the fulfillment of their functions. The obligation is contained in Article 105, subsection 1 of the Charter and was further developed in the Convention on Privileges and Immunities. That convention provides that the United Nations, as well as its officials, property, and assets, are immune from every form of legal process. Recently enacted Israeli laws that target UNRWA by revoking its privileges and immunities and allowing potential criminal proceedings against UNRWA. Officials breach these duties. Finally, the Convention states the undisputed principle that the premises of the United Nations shall be inviolable. This obligation has several implications. First, Israeli authorities may not enter the premises of the United Nations or its organs without their consent. Second, Israel has a positive duty to protect and safeguard those premises from external threats. And third, Israel must not attack those premises. Importantly, these obligations are not qualified and do not cease to apply in situations of armed conflict. Thus, Israel's failure to guarantee the inviolability of UN premises can never be justified on grounds of military expediency or national security. I now turn to Israel's obligation to respect the Palestinian people's established right to self-determination. I use Cogan's norm, generating obligations erga omnes. If that obligation is to mean anything, it surely requires At a minimum that Israel allow the provision of humanitarian development assistance to the Palestinian people by those prepared to give it so as to strengthen their ability to achieve self-determination. Israel's refusal to comply with that imperative while perpetrating unspeakable violence on the Palestinian people can only confirm the war's fears about its intentions. The court's voice confirming the scope and nature of Israel's obligations to ensure and facilitate humanitarian development assistance to the Palestinian population will serve as a powerful force in preventing those fears from becoming a reality. In closing, the Kingdom of Saudi Arabia wishes to emphasize that the Palestinian people's right to self-determination is at the core of the question before the court. The Kingdom takes this opportunity to reaffirm its unconditional commitment to the establishment of an independent and sovereign Palestinian state with the 1967 borders with East Jerusalem as its capital. This unwavering position is non-negotiable and is not subject to compromises. Mr. President, distinguished members of the court, thank you for your attention. This concludes the statement of the Kingdom of Saudi Arabia.
I thank the representative of Saudi Arabia for his presentation. Before I invite the next delegation to take the floor, the court will observe a coffee break of 15 minutes. The hearing is suspended. Please be seated. The sitting is resumed. J'invite à présent la délégation suivante, celle de la Belgique, à prendre la parole et appelle à la barre Monsieur Antoine Misson. Monsieur, je vous en prie.
Monsieur le Président, honorables membres de la Cour, c'est un grand honneur pour moi de comparaître devant vous en tant qu'agent du Royaume de Belgique dans cette procédure concernant la demande d'avis consultatif soumise à la Cour par l'Assemblée générale des Nations unies dans sa résolution du 19 décembre 2024. Comme la Belgique a déjà eu l'occasion de le souligner, je cite, « Le respect du droit international, en ce compris le droit international humanitaire et des droits humains, est une pierre angulaire de la paix et de la sécurité. » Fin de citation. Le conflit actuel à Gaza a mis, et met toujours, le droit international à rude épreuve. C'est précisément à des occasions comme celle-ci qu'il est indispensable de réaffirmer sans équivoque notre soutien aux normes internationales qui assurent la coexistence pacifique au sein de la communauté internationale. Eu égard au temps qui lui est imparti, la Belgique approfondira certains éléments traités dans son exposé écrit à la lumière d'arguments invoqués par d'autres intervenants dans la présente procédure. Pour les autres aspects de la question, la Belgique renvoie respectueusement la Cour au développement contenu dans son exposé écrit. Avec votre permission, j'aborderai dans un premier temps, brièvement, la question de l'exercice du pouvoir discrétionnaire de votre Cour. Dans un deuxième temps, je m'attarderai sur les obligations d'Israël en tant que membre de l'Organisation des Nations Unies. Le professeur Vaios Koutroulis se penchera ensuite sur les obligations d'Israël relatives à la fourniture de l'aide humanitaire. Monsieur le Président, pour respecter le droit international, il est nécessaire de connaître la portée de ces règles. Selon la jurisprudence constante de la Cour, quand celle-ci est appelée à rendre un avis consultatif, elle ne devrait pas refuser de répondre à la demande, sauf s'il existe des raisons décisives pour le faire. Or, aucun argument qui pourrait amener la Cour à refuser de donner un avis consultatif n'a été invoqué dans les exposés écrits des participants à cette procédure. En réalité, la grande majorité des arguments avaient déjà été invoqués devant la Cour et rejetés par celle-ci dans le cadre des procédures consultatives précédentes. Par ailleurs, si aucun des arguments invoqués ne constitue une raison décisive justifiant l'exercice par la Cour de son pouvoir discrétionnaire, il est évident que le fait de considérer les mêmes arguments cumulativement ne devrait pas modifier cette conclusion. En réalité, la présente procédure aidera l'Assemblée générale à remplir son rôle et ses fonctions. Elle est nécessaire parce que les deux avis consultatifs précédents, rendus par votre Cour et portant sur la même situation générale, n'ont pas été mis en œuvre. Il est ainsi difficile, pour dire le moins, de voir dans cette nouvelle procédure une instrumentalisation ou une utilisation abusive quelconque de la Cour. Au contraire, la Cour est ici appelée à jouer son rôle, dire le droit pour que toutes les parties concernées agissent en conséquence. Ainsi, la Belgique invite la Cour à reconnaître qu'il n'y a aucune raison décisive qui justifierait de ne pas répondre à la demande d'avis consultatif de l'Assemblée générale. J'en viens maintenant à la seconde partie de mon exposé qui porte sur les obligations d'Israël en tant que membre des Nations unies. En tant que membre de l'ONU, tout État assume certaines obligations à l'égard de l'organisation, de ses organes et de son personnel, en vertu de la Charte des Nations Unies. En outre, d'autres conventions, comme la Convention de 1946 sur les privilèges et immunités des Nations Unies, emportent des obligations pertinentes, supplémentaires, applicables à Israël. Dans ce cadre, respecter le droit international implique de coopérer avec l'ONU et de l'assister dans son action en évitant d'agir unilatéralement. Tout d'abord, l'article 2, paragraphe 5 de la Charte prévoit que les États membres de l'ONU, je cite, « donnent à celle-ci pleine assistance dans toute action entreprise par elle, conformément aux dispositions de la présente Charte ». Fin de citation. Comme il ressort du texte de la disposition, cette obligation s'applique à toute action entreprise par l'ONU, à savoir toute action de tout organe de l'ONU. Elle n'est dès lors pas limitée aux décisions du Conseil de sécurité adoptées en vertu du chapitre 7 de la Charte et couvre également la présence et les activités d'organes comme l'Office de secours et de travaux des Nations Unies pour les réfugiés de Palestine dans le Proche-Orient, l'UNRWA. Évidemment, le déploiement de l'ONU et de son personnel sur le territoire d'un État nécessite son consentement. Toutefois, cela concerne uniquement le territoire sur lequel un État exerce sa souveraineté. Or, comme la Cour l'a confirmé dans l'avis consultatif du 19 juillet 2024, je cite, « Israël n'a pas le droit à la souveraineté sur quelque partie du territoire palestinien occupé et ne saurait y exercer des pouvoirs souverains du fait de son occupation. » Fin de citation. Il en découle qu'Israël ne peut pas subordonner à son consentement la présence et les activités ne peut pas subordonner à son consentement la présence et les activités de l'ONU, des organes et agences onusiens et du personnel onusien sur le territoire palestinien occupé. L'obligation de coopération et d'assistance à toute action de l'ONU peut ainsi sortir son plein effet à l'égard des activités de l'ONU, y compris de l'UNRWA, en territoire palestinien occupé. Les mesures prises unilatéralement à l'égard de l'UNRWA reposent notamment sur des allégations relatives à la violation de la neutralité par les membres de son personnel. Ces allégations sont extrêmement graves et doivent évidemment être prises au sérieux. L'ONU n'est pas restée inactive face à ces allégations. Comme d'autres participants à la présente procédure, la Belgique souligne les enquêtes menées par le Bureau des services de contrôle interne, BSCI, qui ont abouti au licenciement des personnes contre lesquelles il existait des éléments de preuve indiquant qu'elles pourraient avoir été impliquées dans les attaques du 7 octobre 2023. En outre, l'ONU a demandé une évaluation indépendante des mécanismes et procédures visant à assurer le respect du principe de neutralité par l'UNRWA. Le rapport, dans ce cadre, atteste, entre autres, du fait que l'UNRWA a examiné toutes les allégations externes de manquement à la neutralité et a ouvert des enquêtes dans les cas où, prima facie, il existait des preuves de mauvaise conduite. Par ailleurs, le rapport indique qu'Israël n'a pas fourni de preuves à l'appui de ces allégations selon lesquelles un nombre significatif d'employés de l'UNRWA sont membres d'organisations terroristes. Ainsi, nous sommes loin de l'image dépeinte par Israël au sein du Conseil de sécurité, selon laquelle, je cite, « l'UNRWA est un maillon essentiel du dispositif terroriste du Hamas, ce qui fait de l'UNRWA elle-même une organisation terroriste et que, à Gaza, le Hamas est l'ONU et l'ONU est le Hamas. » Fin de citation. La Belgique rejette de telles qualifications et considère ainsi que les résolutions du Conseil de sécurité relatives au terrorisme sont sans pertinence pour cet avis consultatif. Au vu de ce qui précède, les actions unilatérales prises contre l'ONU et plus particulièrement contre l'UNRWA sont non seulement injustifiées, mais aussi en violation des obligations assumées par les États membres des Nations Unies. Les problèmes et griefs relatifs aux actions de l'ONU doivent être résolus avec l'organisation et non contre elle. Ceci conclut le deuxième point de l'exposé oral de la Belgique. Monsieur le Président, je vous prie maintenant de donner la parole au professeur Vaios Koutroulis pour poursuivre la présentation des observations de la Belgique. Je vous remercie de votre attention.
Je remercie M. Misson. Je donne maintenant la parole au professeur Vaios Koutroulis. Monsieur, vous avez la parole.
Monsieur le Président, honorables membres de la Cour, c'est un immense honneur pour moi de me présenter une nouvelle fois devant vous au nom du Royaume de Belgique. Je poursuivrai l'exposé oral de la Belgique en me penchant sur les obligations d'Israël relatives à la fourniture de l'aide humanitaire. Avec la reprise des hostilités, Israël a bloqué une nouvelle fois le 2 mars 2025, l'entrée de l'aide humanitaire à Gaza. Les mises à jour sur la situation humanitaire à Gaza, publiées début avril 2025 par le Bureau de la coordination des affaires humanitaires des Nations Unies, font état, entre autres, du fait que les médicaments s'épuisent rapidement, la majorité des mouvements et missions d'assistance humanitaire coordonnés avec les autorités israéliennes ont été refusés. Gaza est confronté à un nouveau risque de famine et de malnutrition. L'accès à l'eau reste très limité et très inégal. Et les conditions d'assainissement restent alarmantes et sont susceptibles d'aggraver les risques pour la santé publique. Il est ainsi nécessaire et urgent de rappeler les obligations d'Israël relatives à la fourniture de l'aide humanitaire et d'en clarifier le contenu, gardant à l'esprit que ces obligations doivent être interprétées et appliquées de bonne foi. Dans un premier temps, je m'attarderai sur le contenu des obligations issues du droit international humanitaire, spécifiquement. Dans un deuxième temps, j'insisterai sur l'absence des raisons pouvant justifier la violation de ces obligations. Monsieur le Président, les obligations d'Israël en matière de fourniture de l'aide humanitaire découlent non seulement du droit international humanitaire, mais aussi, notamment, du droit international des droits humains, du droit à l'autodétermination, des résolutions pertinentes des Nations Unies et des mesures conservatoires pertinentes ordonnées par la Cour dans l'affaire opposant l'Afrique du Sud à Israël. Ce cadre juridique impose à la puissance occupante des obligations tant positives que négatives. Début avril 2025, le nombre de travailleurs humanitaires tués depuis octobre 2023 a dépassé les 400. Malheureusement, nous n'avons pas d'autre choix que de rappeler qu'il est interdit d'attaquer des secouristes et travailleurs humanitaires, surtout quand ils circulent dans des véhicules avec la signalisation appropriée et les gyrophares allumés. Concernant le droit humanitaire plus particulièrement, en vertu de l'article 55 de la 4e Convention de Genève de 1949, en tant que puissance occupante, Israël a l'obligation principale de fournir de l'assistance humanitaire à la population du territoire occupé, je cite, « dans toute la mesure de ses moyens ». Fin de citation. Quand, en dépit de cette obligation, la population civile reste insuffisamment approvisionnée, l'article 59 de la même convention prévoit que, je cite, « la puissance occupante acceptera les actions de secours faites en faveur de cette population et le facilitera dans toute la mesure de ses moyens. » Fin de citation. Les termes « insuffisamment approvisionnés » doivent être interprétés de bonne foi à la lumière des autres règles du droit international applicables, y compris celles issues du droit international des droits humains. Par exemple, en vertu de l'article 43 du règlement de La Haye de 1907, la puissance occupante a l'obligation générale d'administrer les territoires occupés, d'y assurer, je cite, « l'ordre et la vie publique ». Fin de citation. Dans les articles 11 et 12 du Pacte international des droits économiques, sociaux et culturels, il est annoncé le droit à l'eau et le droit à un niveau de vie suffisant pour chaque personne et sa famille, y compris une nourriture, un vêtement et un logement suffisant. Le Comité des droits économiques, sociaux et culturels explique que le droit à une nourriture suffisante, énoncé dans l'article 11 du pacte, je cite, ne doit pas être interprété dans le sens étroit ou restrictif du droit à une ration minimum des calories, des protéines ou d'autres nutriments spécifiques. Fin de citation. Le même comité affirme que, je cite à nouveau, la notion d'approvisionnement en eau adéquat doit être interprétée d'une manière compatible avec la dignité humaine et non au sens étroit en faisant simplement référence à des critères de volume. Il découle de ce qui précède que la puissance occupante n'a pas uniquement une obligation de maintenir la population civile en vie. Après tout, en territoire occupé, l'occupant doit assurer l'ordre et la vie publique et pas simplement la vie des civils. Ainsi, pour que la population civile soit considérée comme insuffisamment approvisionnée, elle ne doit pas être au bord de la famine ou voir sa survie menacée. En l'occurrence, il n'y a pas de doute que la population civile dans la bande de Gaza est insuffisamment approvisionnée. Par conséquent, Israël doit accepter et faciliter les actions de secours des organisations internationales, des États tiers et des organismes humanitaires impartiaux. Après ces remarques sur le contenu des obligations de la puissance occupante en droit humanitaire, je me pencherai sur l'absence des raisons pouvant justifier la violation de ces obligations. Et il s'agit du dernier point qui sera soulevé par la Belgique. Monsieur le Président, respecter les obligations relatives à la fourniture de l'aide humanitaire et les appliquer raisonnablement implique de ne pas chercher à s'en dédouaner en invoquant des justifications non admises en droit international. En l'occurrence, ce sont des intérêts militaires et de sécurité qui sont mis en avant pour justifier des comportements non conformes aux obligations du droit international humanitaire. En lien avec cette justification, la Belgique se permet d'insister sur 3 points. Premièrement, dans la mesure où les intérêts militaires et de sécurité renvoient à la licéité ou la légitimité du recours à la force, la Belgique rappelle que de telles considérations ne peuvent affecter ni l'applicabilité des règles du droit humanitaire, ni la manière dont ces règles sont interprétées et appliquées aux parties belligérantes. C'est ce que prévoit le principe de l'égalité des belligérants, principe cardinal du droit humanitaire, fondé, entre autres, sur l'article 1er commun aux 4 conventions de Genève. Deuxièmement, si l'argument renvoie aux nécessités militaires, ces dernières sont déjà prises en compte dans l'élaboration de toutes règles du droit humanitaire. Elles ne peuvent ainsi pas être invoquées une deuxième fois pour justifier les violations de ce droit. En outre, l'article 43 du règlement de La Haye, qui serait prétendument la source d'une excuse générale en faveur des nécessités militaires de la puissance occupante, en réalité, n'énonce rien de la sorte. L'article prévoit notamment que, je cite, « l'occupant prendra toutes les mesures qui dépendent de lui en vue de rétablir et d'assurer, autant qu'il est possible, l'ordre et la vie publique. » Fin de citation. Ce texte ne contient aucune référence explicite aux intérêts militaires. Au contraire, l'accent est résolument mis sur l'obligation pour la puissance occupante de prendre toutes mesures possibles pour assurer l'ordre et la vie publique. L'article 43 du règlement de La Haye ne peut dès lors pas servir de fondement d'une excuse générale liée aux nécessités militaires. Encore moins pour justifier des violations des obligations issues d'une autre convention, la 4e convention de Genève. Obligations qui ne sont pas subordonnées à l'article 43 du règlement de La Haye. Troisièmement et enfin, les intérêts militaires de la puissance occupante ne sont évidemment pas méconnus par les droits humanitaires. Au contraire, ils sont pris en compte dans toute règle de ce droit. Dès lors, les intérêts militaires ne peuvent être invoqués que dans la mesure où les dispositions pertinentes le prévoient. Si une règle énonce une obligation inconditionnelle, alors la puissance occupante ne pourra pas invoquer ses intérêts militaires pour ne pas s'y conformer. Si la formulation d'une disposition permet la prise en compte des intérêts militaires de la puissance occupante, leur invocation ne sera pas problématique tant qu'elle reste dans les limites prévues par la règle pertinente. Cette interprétation doit toujours être faite de bonne foi. Ainsi, par exemple, imposer des procédures ou des conditions d'accès à ce point contraignantes qu'elles rendent la fourniture de l'aide humanitaire impossible ou impraticable équivaut à refuser l'accès à l'aide humanitaire. Elle ne pourra pas être justifiée par des considérations militaires. Monsieur le Président, plusieurs intervenants se sont montrés sensibles aux intérêts militaires et de sécurité d'Israël. Tout au long de sa présentation, la Belgique s'est permise d'insister sur le respect du droit international pour souligner une idée aussi simple qu'essentiel. Les intérêts militaires et de sécurité d'un État doivent s'exercer conformément au droit international, pas en dépit du droit international. Monsieur le Président, honorables membres de la Cour, cela conclut l'exposé oral du Royaume de Belgique. Je vous remercie pour votre aimable attention.
Je remercie les représentants de la Belgique pour leur présentation. I now invite the delegation of Colombia to make its oral statement, and I call His Excellency Mauricio Ramio to the podium. You have the floor, sir.
Mr. President, Madam Vice President, distinguished members of the Court, it is an honor to appear before you today on behalf of the Republic of Colombia. Colombia stands before this Court to express its grave concern over the dire humanitarian situation in the occupied Palestinian territory, a situation caused by Israel and further exacerbated by its own plans and measures that interfere with the United Nations' presence and operations in the field. This concern, broadly shared by the international community, has led the General Assembly to seek urgent guidance from the Court through these expediting proceedings. In line with its consistent commitment to full realization of the inalienable right of the Palestinian people to self-determination, Colombia actively supported and promptly sponsored Resolution 79-232 of 19 December 2024. Our presence here is also a reaffirmation of Colombia's long-standing tradition of respect for international law. Furthermore, Colombia is before you today in compliance with the duty incumbent upon all states, as the Court has reaffirmed, to ensure that any impediment to the exercise of the Palestinian people of its right to self-determination resulting from the illegal presence of Israel in the occupied Palestinian territory is brought to an end. Colombia thus categorically rejects any recourse to violence or unilateral act that leads to a higher level of confrontation and expresses its particular alarm for the deteriorating humanitarian situation in the Gaza Strip, where after months of continuing siege and ongoing attacks on civilians and infrastructure, hostilities have intensified even as these proceedings are conducted. Colombia contends that Israel has engaged in escalating conducts which have put the Palestinian population in an impossible position, on top of a dire humanitarian crisis that Israel itself has created. Israel has now placed serious impediments for international organizations as well as third states to fulfill their respective mandates and obligations under international law. Israel has made the Palestinian population subject exclusively to its power and has impeded the work of relief agencies, which have been the only protection for the starving population, a population already facing the threat of constant war and destruction, and depriving it of the lone source of food, health, or education. Colombia submits that such conduct is inconsistent with Israel's status as occupying power, unlawful as the occupation itself is, and constitutes a breach of its obligation as member of the United Nations and under international humanitarian and human rights law. Against this background, I shall first refer to Colombia's views on the jurisdiction and discretion of the Court. Thereafter, I will refer to Israel's obligation arising both from its status as a member of the United Nations and under international humanitarian law, as well as the legal consequences entailed from its international wrongful acts. Finally, I will conclude this statement by setting out a series of final observations. Mr. President, a handful of states have urged the court to exercise its discretion to refrain from issuing the requested opinion, contending that it might affect or prejudge determinations to be made in the contentious proceedings initiated by South Africa against Israel. Colombia firmly rejects this reasoning. Advisory proceedings should never be used to bring to the court matters that are essentially bilateral. Nonetheless, in the present proceedings, the question refers to a wide range of issues that are of general concern. This is confirmed by the fact that an overwhelming number of member states decided it was fundamental for the General Assembly to receive guidance on the question put to the court. The General Assembly, moreover, was emphatic in expressing the view that developments on the ground, particularly those which could prevent UNRWA and other agencies, as well as third states, from continuing its essential work in the occupied Palestinian territory, demand consideration and guidance from the court on a priority basis and with the utmost urgency. The General Assembly is therefore in acute need of this guidance. Colombia will now focus on three topics which, in our view, could serve as guidance to the court in addressing the question posed by the General Assembly. First, the centrality of the right of the Palestinian people to self-determination and Israel's corresponding obligation to bring the occupation to an end. Second, Israel's responsibilities arising from its status as a member state of the United Nations and under international humanitarian law. Finally, the legal consequences entailed by Israel's international wrongful acts. Mr. President, distinguished members of the Court, General Assembly Resolution 79-232 takes at its point of departure and point of arrival the inalienable right of all peoples to self-determination, hence recognizing it as one of the essential principles guiding the obligations under the relevant rules of international law applicable that shall also guide the activities of Israel as the occupying power in the occupied Palestinian territory with regard to the right of the Palestinian people. In this vein, Colombia recalls that, as mentioned by the court in the legal consequences advisory opinion, Israel as the occupying power has the obligation not to impede the Palestinian people from exercising its right to self-determination, including its right to an independent and sovereign state over the entirety of the occupied Palestinian territory. The centrality of the right to self-determination as, I quote, one of the essential principles of contemporary international law is enshrined in the Charter of the United Nations and is recognized as a rule of customary international law vested with the status of jus cogens norm. This court has further recognized that the obligation to respect the right to self-determination is an erga omnes obligation, thus implying that all states have a legal interest in ensuring its protection. It follows that a paramount and corresponding obligation incumbent upon Israel, given its prolonged and unlawful presence in the occupied Palestinian territory, is to bring its occupation to an end as rapidly as possible, as consistently pointed out by relevant United Nations organs. With this framework in mind, we turn now to Colombia's second point, namely that of Israel's responsibilities arising from its status as a member state of the United Nations and under international humanitarian law with respect to the presence and operations of the United Nations, its agencies, other organizations, and even third states in and concerning the occupied Palestinian territory. The Republic of Colombia is of the view that Israel, as a member of the United States, is subject to two core obligations. First, to fulfill in good faith the obligation it has undertaken under and in accordance with the Charter of the United Nations, and second, to assist the United Nations in any action it takes pursuant to the Charter. With regard to the first obligation, Article 2, Paragraph 2 of the Charter require Israel to fulfill in good faith the obligations it accepted when it ratified this treaty, which in any event prevail over any other obligation according to Article 103. In line with the general obligation, Section 34 of the General Convention of the Privileges and Immunities of the United Nations of 1949 provides that, I quote, when an instrument of accession is deposited on behalf of any member, the member will be in a position under its own law to give effect to the terms of this convention. Therefore, Israel, as a state party to this convention since 1949, is bound by the obligations contained therein and must fulfill them in good faith with regard to the United Nations, including UNRWA, an agency of the organization. Regarding the second obligation, Article 2, Paragraph 5 of the Charter, which refers to the obligation of assistance owed to the organization by all member states, it constitutes an essential element to allow the United Nations to fulfill its purposes and principles. The terminology employed in this provision is unambiguous, and it establishes a broad obligation encompassing every assistance in any action undertaken by the United Nations. The above extends to agencies and bodies of the organizations established under Article 22 of the Charter, such as UNRWA, whose mandate is to implement resolutions issued by the General Assembly, thus constituting actions taken by the United Nations in accordance with the Charter. Therefore, Colombia considers that as a member of the United Nations, Israel is required to give UNRWA every assistance in any action it takes in accordance with the Charter, including by fulfilling its obligations under the General Convention and the exchange of letters in relations with UNRWA. Colombia shares the view of several states which in their written statements expressed that Israel must comply with the obligation encompassed in the condition of its admission to membership in the United Nations, as contained in General Assembly Resolution 273 of 1949. In this regard, to honor the commitment undertaken upon its admission to the United Nations, the State of Israel is obliged to fully and faithfully comply with the provisions of the Charter in relation to the presence and activities of the United Nations. This entails, inter alia, bring an end to the occupation, cease all violations of the Palestinian people's right to self-determination, uphold the privileges and immunities of United Nations property and personnel, refrain from any interference with the delivery of humanitarian assistance, whether rendered by UNRWA, other agencies or organizations, or third states, and more broadly, conduct itself as a peace-loving state in accordance with the principles of international law, and particularly of international humanitarian law, as it will be further elaborated below. Mesdames et Messieurs les membres de la Cour, le statut d'Israël en tant que puissance occupante sur l'ensemble des territoires palestiniens occupés a été confirmé par la Cour, en raison du contrôle effectif qu'il exerce sur ces territoires depuis au moins 1967. En conséquence, Israël a depuis lors été tenu de respecter les droits internationaux humanitaires en vigueur, y compris la 4e Convention de Genève, le règlement de la haie de 1907 et les règles pertinentes du droit international humanitaire de nature coutumière. La situation humanitaire actuelle rend encore plus impérieux le respect par Israël de ses obligations juridiques respectives. Je vais maintenant présenter une série de considérations relatives aux obligations spécifiques qu'Israël doit observer en tant que puissance occupante conformément au droit international humanitaire en ce qui concerne notamment la présence et les activités de l'ONU dans les territoires palestiniens occupés. En premier lieu, Comme elle l'a indiqué dans son exposé écrit, la Colombie souligne qu'assurer l'aide humanitaire et les services de base à la population civile du territoire palestinien occupé est indispensable pour garantir sa protection et sa subsistance. En tant que puissance occupante, Israël est responsable de l'administration de ces territoires et a donc l'obligation d'agir dans l'intérêt de la population civile qui y réside. Par conséquent, Israël est lié par plusieurs règles régissant l'aide humanitaire dans le contexte de l'occupation. Premièrement, dans le contexte d'un conflit armé international, l'article 23 de la 4e Convention de Genève impose à Israël l'obligation générale d'accorder les libres passages aux envois humanitaires destinés aux civils. Deuxièmement, en vertu du droit international coutumier, Israël, en tant que puissance occupante, doit veiller à ce que tous les articles et fournitures nécessaires à la survie de la population civile soient disponibles. En outre, en vertu de l'article 59 de la 4e Convention de Genève, Israël est tenu d'accepter au nom de la population civile les actions de secours qui pourraient être entreprises soit par des États tiers, soit par des organisations humanitaires impartiales lorsque les besoins de la population ne sont pas satisfaits. La Colombie note que tout au long de cette procédure, plusieurs États ont souligné que l'incapacité d'Israël à répondre aux besoins de la population civile constitue une violation du droit international humanitaire. De même, la Colombie soutient qu'Israël ne peut simplement se soustraire à son obligation de permettre les livres passages des envois humanitaires en se basant sur ses propres présomptions. Pour être exempté de ces obligations, Israël doit fournir des preuves concrètes établissant que les besoins de la population civile sont suffisamment satisfaits. La Colombie considère que tel n'est pas le cas, Israël ne pouvant pas occulter le rôle indispensable de la UNRWA. De ce fait, la grande majorité des participants à cette procédure ont démontré qu'aucun autre organisme ne dispose de l'infrastructure, des capacités et de l'expérience nécessaires pour s'acquitter des mandats spécifiques confiés à l'UNRWA. La Colombie considère donc qu'Israël manque à son obligation, en vertu du droit international humanitaire, de s'abstenir de toute action entravant la fourniture des services de base et de l'aide humanitaire à la population palestinienne. Monsieur le Président, Mesdames, Messieurs les membres de la Cour, Israël est tenu de s'abstenir d'attaquer, de détruire, d'enlever ou de rendre inutilisable les biens essentiels à la survie de la population civile. La Colombie soutient qu'Israël, en tant que puissance occupante, doit s'abstenir de cibler les installations médicales, les personnels médicaux, les véhicules d'urgence et doit cesser d'utiliser ces installations médicales à des fins militaires, conformément au droit international humanitaire en usage. Il doit également garantir aux blessés un accès rapide, sécurisé et sans entrave du personnel médical et des ambulances. D'autre part, en dépit des arguments mettant en avant de manière excessive les préoccupations de la puissance occupante en matière de sécurité, le régime international de l'occupation établit un équilibre délicat entre l'aide humanitaire et ses préoccupations, à savoir les droits de contrôle énoncés aux articles 23 et 59 et 61 de la 4e Convention de Genève. Ces dispositions ne sauraient être interprétées comme autorisant des restrictions excessives ou généralisées fondées sur des motifs de sécurité. Celles de nécessité militaire impérieuse à une portée temporelle et géographique spécifique peuvent limiter les envois d'aide humanitaire à un niveau raisonnable. Par conséquent, Israël n'est pas en droit d'invoquer des préoccupations de sécurité en tant que limite générale à la présence et aux activités des tiers parties qui fournissent une aide urgente et vitale à la population civile. En l'absence de raisons sérieuses et crédibles, les États ne peuvent légalement empêcher ou entraver la fourniture d'aide humanitaire lorsque les besoins fondamentaux de la population civile ne sont pas satisfaits. Si des conditions exigent certaines mesures pour répondre aux préoccupations de la puissance occupante en matière de sécurité, elles doivent être traitées conformément au droit international et non dans le cadre de la législation nationale. En raison de ces restrictions justifiées à l'entrée de l'aide humanitaire, la Colombie considère qu'Israël, en empêchant l'accès des biens et des fournitures à Gaza, viole de manière flagrante l'interdiction de la famine comme méthode de guerre, conformément au paragraphe 1er de l'article 54 du protocole additionnel 1er et l'article 14 du protocole additionnel 2e. La Colombie estime qu'il est urgent d'assurer le respect de cette obligation, étant donné que la population de la bande de Gaza est confrontée à une insécurité alimentaire aiguë et risque la famine. Cette urgence a été rappelée dans l'ordonnance de mesures conservatoires par la Cour le 26 janvier 2024 dans l'affaire Afrique du Sud, Israël du 26 janvier 2024, dans laquelle il a demandé à Israël de prendre, je cite, toutes les mesures en son pouvoir pour empêcher la commission de tous les actes relevant de l'article 2e de la Convention sur le génocide de 1948. Monsieur le Président, conformément au but des principes de l'ONU, celle-ci a toujours mis en œuvre un ensemble de mandats essentiels dans les territoires palestiniens occupés. Parmi ceux-ci, la fourniture constante d'une aide humanitaire vitale à la population palestinienne réfugiée enregistrée par l'UNRWA. La Colombie partage le vues exprimées dans plusieurs exposés écrits selon lesquels les conditions et les lacunes qui ont conduit l'Assemblée générale à créer l'UNRWA sont toujours présentes aujourd'hui et n'ont fait que se détériorer au cours des dernières années, rendant son travail encore plus nécessaire et irremplaçable à l'époque de sa création. Dans ce contexte préoccupant, la Colombie rappelle qu'une règle du droit international ne s'applique pas dans les vides, mais en relation avec les faits et dans le contexte d'un cadre juridique plus large dont elle ne constitue qu'une partie. Par conséquent, compte tenu du cadre actuel des faits et des droits, en cessant ou en limitant les activités et les opérations de la UNRWA, Israël, en tant que puissance occupante, priverait de fait la population civile du territoire palestinien occupé de fournitures dont elle a besoin d'urgence et qui sont essentielles à sa survie. L'État d'Israël manque donc ouvertement aux obligations qui lui incombent en vertu du droit international humanitaire, en raison de ces actes et omissions qui interfèrent ou entravent la présence et les opérations de l'Organisation des Nations Unies dans les territoires palestiniens occupés et en relation avec celui-ci. Ces comportements impliquent sa responsabilité internationale, un aspect que je vais aborder maintenant. Monsieur le Président, la Cour a une tradition bien établie d'aborder les conséquences des faits illicites dans ses avis consultatifs. Par exemple, dans les avis consultatifs sur les murs 2004, sur les conséquences juridiques, la Cour a fourni des orientations sur les conséquences juridiques des violations du droit international, précisant à la fois les responsabilités de l'État contrevenant et les obligations de cet État. À cet égard, la Cour a déjà considéré que la présence illégale d'Israël constitue un fait internationalement illicite, continu, engageant ainsi sa responsabilité internationale. À la lumière de ces précédents, la Colombie invite la Cour à compléter ses orientations concernant les conséquences juridiques découlant des manquements d'Israël à ses obligations énoncées dans ses deux avis consultatifs et soumet ce qui suit. Premièrement, comme le reflète l'article 30 du projet d'article de la CDI sur la responsabilité de l'État, Israël a l'obligation de cesser tout acte illégal envers les Nations Unies, les organisations internationales et les États tiers en ce qui concerne leur présence et leurs activités dans les territoires palestiniens occupés et en relation avec celui-ci. Plus précisément, Israël est tenu d'annuler toutes les mesures qui entravent fourniture des services de base, de l'aide humanitaire et d'une aide au développement au peuple palestinien, y compris la législation qu'il a adoptée en octobre 2024 visant à restreindre les opérations de l'UNRWA. Deuxièmement, comme le prévoit l'article 30b du projet d'article de la CDI, Israël a l'obligation de, je cite, fournir des assurances, des garanties appropriées de non-répétition, fin de la citation, en ce qui concerne les faits qui ont fondé ces requêtes d'avis consultatifs de l'Assemblée générale. Troisièmement, en ce qui concerne la réparation des dommages causés, bien que certaines actions de la puissance occupante aient entraîné des dommages irréversibles, certaines circonstances peuvent encore être corrigées et rétablies à leur état antérieur. Et lorsque cela est possible, tous les efforts doivent être faits pour obtenir la restitution. Toutefois, si cela n'est pas faisable, une indemnisation est justifiée pour les préjudices infligés à la population protégée. Monsieur le Président, Mesdames et Messieurs, membres de la Cour, pour conclure, je soumets respectueusement au nom de la Colombie les considérations suivantes. Israël, en tant que puissance occupante et État membre de l'ONU, ainsi qu'en tant que partie de la 4e Convention de Genève et à la Convention sur les génocides, en plus de ses obligations découlant du droit international humanitaire, reste lié par ses obligations et responsabilités dans les territoires palestiniens occupés jusqu'à ce qu'il soit mis fin à la présence israélienne le plus rapidement possible. En tant que puissance occupante, Israël est légalement tenu de veiller à ce que les opérations de secours humanitaire soient menées sans imposer des conditions injustifiées ou arbitraires qui contreviennent directement aux principes et obligations fondamentaux consacrés par les droits internationaux humanitaires, en particulier ceux qui incombent à la puissance occupante pendant l'occupation, dans les meilleurs intérêts de toutes les personnes protégées qui sont placées sous son contrôle effectif. La Colombie considère également qu'en refusant arbitrairement de donner son consentement à l'UNRWA de poursuivre ces opérations et en entravant le travail d'autres organisations internationales dans les territoires palestiniens occupés, Israël condamne la population de Gaza à une aggravation de la crise humanitaire. Autant donné qu'il est généralement admis qu'un tel consentement ne doit pas être refusé arbitrairement dans des circonstances comme celles auxquelles sont confrontés les réfugiés palestiniens, un tel refus ne peut que constituer une violation par Israël de ses obligations en vertu du droit international en ce qui concerne le traitement de la population civile en question. La Colombie fait valoir qu'en vertu du droit de la responsabilité de l'État, dans la mesure où il s'agit d'une violation continue de ses obligations internationales, objet de la présente requête de l'Assemblée générale, Israël est tenu de prendre toutes les mesures pertinentes pour assurer la cessation, la non-répétition et la réparation de ces violations. Enfin, la Colombie est convaincue que, comme la Cour l'a rappelé il y a 2 décennies, l'Organisation des Nations Unies possède, je cite, une responsabilité permanente à assumer en ce qui concerne la question de Palestine, jusqu'à ce qu'elle soit réglée sur tous ces aspects de manière satisfaisante et dans le respect de la légitimité internationale. Fin de la citation. Et il en va de même pour la Cour en tant que la principale organe judiciaire de l'ONU. Monsieur le Président, Mesdames, Messieurs les membres de la Cour, je vous remercie de votre attention. Ceci conclut l'intervention de la République de Colombie.
I thank the representative of Colombia for his presentation. This concludes this morning's sitting. The oral proceedings will resume this afternoon at 3 p.m. in order for Bolivia, Brazil, Chile, and Spain to be heard on the questions submitted to the court. The sitting is closed.
As intransgressible principles. These include absolute prohibitions under international humanitarian law against collective punishment, deliberate starvation, attacks on objects indispensable to survival and respect for non-derogable human rights. Widespread denial of essential aid amounts to a breach of these fundamental rules. Second, even where international humanitarian law permits security exceptions, these exceptions are narrowly defined and strictly conditioned. The obligation under Article 59 of the 4th Geneva Convention to agree to and facilitate relief contains no explicit security exception allowing refusal or systematic obstruction of relief schemes undertaken by states or impartial organizations. In any event, its requirements relating to population under occupation are distinct from the limited ability of a state to control access to third-party aid within its territory. Third, Israel's security concerns cannot displace the specific and generally absolute nature of the privileges and immunities of the UN. UNRWA, as a UN organ, benefits from these protections under the Charter and the General Convention. Article 105 of the Charter obliges all members to grant the organization and its officials the privileges and immunities necessary for the fulfillment of its purposes and necessary for the independent exercise of their functions. The General Convention implements this Charter duty without replacing it or superseding it. These protections cannot be overridden by any security exceptions stemming from international humanitarian law. Specifically, the inviolability of UN premises under Article 2, Section 3 of the General Convention is absolute. It admits no exception, whether because of alleged misuse or security concerns asserted unilaterally by the occupying power or any other basis. As to the functional immunities of UN personnel, Israel cannot unilaterally decide whether specific conduct falls outside of the official function. That determination lies within the Secretary General or his delegate, UNRWA's Commissioner General, and concerns about individuals must be addressed through established UN channels, including, where appropriate, through seeking a waiver. Finally, even if security measures were permitted, they would have to be applied in good faith, consistent with Article 2, Paragraph 2 of the Charter and customary international law. Israel's invocation of security is undermined by the disproportionate and systematic nature of its actions. Mr. President, members of the Court, this concludes my presentation. I thank you for your attention. May I ask you, Mr. President, to call Professor Ralph Wild to the podium.
I thank Dr. Reddy. I now invite Professor Ralph Wild to address the Court. You have the floor, sir.
Mr. President, distinguished members of the Court, it's a great honour and privilege to appear before you again and represent the plurinational state of Bolivia. As the Court held in its 2024 advisory opinion, Israel's presence in the Palestinian Gaza Strip and West Bank, including East Jerusalem, is, in and of itself, illegal. It's a violation of the legal right of self-determination of the Palestinian people. It's conducted for the unlawful purpose of purported annexation. It must, in the words of the Court, end as rapidly as possible. These findings presuppose that Israel has no valid legal basis to maintain the presence. Had there been a valid legal basis, the Court would not have called for the presence to end. The Court characterized the presence as a use of force, the legality of which determined by the law on the use of force. Since using force without a valid legal basis is a breach of the jus ad bellum, the implication of the Court's finding that the presence should end is that the presence is an unlawful use of force, an aggression. Only the State of Palestine and the Palestinian people have the legal right to exercise authority in the Gaza Strip and West Bank, including East Jerusalem. In consequence, only they have the legal right to decide who can enter and be present there, and which activities those present can engage in. Conversely, as its presence is illegal, Israel necessarily lacks a valid entitlement to do anything there. Insofar, then, as the presence continues, every activity performed is itself illegal, as an integral part of an illegal presence. In consequence, Israel has no legal right to take any action in the OPT restricting the entry, presence and activities of other actors. Any such action, on whatever basis, is therefore illegal. That said, in particular circumstances, the rules regulating the conduct of the Israeli presence, including occupation law, don't prevent and even permit and require certain restrictions on the entry, presence and activities of other actors. Given this, it might be suggested that international law creates a paradoxical, perverse situation. On the one hand, as the court determined, the presence is unlawful and should therefore end as rapidly as possible. On the other hand, because Israel defies the court and continues its illegal presence, obligations are then triggered, permitting it to decide on the presence of other actors, and do so against the wishes of the only legal persons entitled to do this. This suggestion would be to misunderstand the relative significance of the two areas of law. As the court held, the legal rules governing the conduct of the presence apply even though the presence is illegal. However, because of that illegality, all Israel's actions performed as part of the presence will be illegal on this basis, including actions compliant with and pursuant to the rules regulating conduct. Thus, ultimately, restrictions that are lawful according to the rules regulating conduct remain unlawful according to the law of self-determination and the jus ad bellum, since they're performed as part of a presence that is, as a general, unqualified matter, illegal. On this basis, then, Israeli restrictions in the OPT on the entry, presence and activities of other actors are breaches of Israel's obligations owed to the Palestinian people and the State of Palestine. Moreover, such restrictions are also violations of other obligations Israel owes to states. Many states are present in the OPT on a profoundly different basis than Israel, conducting diplomatic relations with the State of Palestine and other Palestinian entities. These and other states also provide material assistance to the Palestinian people there, directly and by supporting provision by others, notably UNRWA. As the court held, because of the fundamental nature of the Palestinian right of self-determination violated by Israel in maintaining its presence in the OPT, all states bear a special legal duty to bring the violation to an end. States discharge this duty through activities seeking to mitigate the violation. Conducting diplomatic relations with Palestinian counterparts in the OPT repudiates Israel's unlawful claim to sovereignty and implicitly or expressly recognizes Palestinian sovereignty. Providing assistance reduces the dependency of the Palestinian people on the state, perpetuating its subjugation of them through its presence. Israeli restrictions conducted in the OPT to the entry, presence and activities of states breach Israel's obligation of non-interference in the freedom of action of these states. More specifically, such restrictions on states and the other actors they support, such as UNRWA, impede their ability to perform activities benefiting the Palestinian people. As a result, they constitute an unlawful interference by Israel in these states' ability to discharge that special legal duty owed to the Palestinian people. In sum, the consequence of the court's finding in the 2024 advisory opinion that Israel's presence in the OPT is, in and of itself, illegal, is as follows. Israel must end its presence. It has no legal right to take any action there restricting the entry, presence and activities of states and international organizations, including UNRWA. Any such action is illegal. This is because it's part of a presence breaching the right of self-determination of the Palestinian people and the jus ad bellum. Also, and in consequence, it violates Israel's obligation not to interfere in the sovereign freedom of action of the states concerned. And, in particular, it violates Israel's obligation not to impede their action of solidarity, whether performed directly or through support given to other actors, discharging the special legal duty owed to the Palestinian people. Mr. President, distinguished members of the court, the peoples of the world are shocked at the continued failure of the international community to end the colonial subjugation and genocide of the Palestinian people. They ask, what is the use of international law? Bolivia is here as one of the states seeking to answer this call, based on the court's determination that states must act and not be bystanders. We respectfully request that the court safeguard states' ability to discharge their special legal duty to act by affirming Israel's obligations not to interfere in this. Mr. President, this concludes my presentation and the submissions of Bolivia. We thank you for your kind attention.
I thank the representatives of Bolivia for their presentation. I now invite the delegation of Brazil to address the court, and I give the floor to Mr. Marcelo Viegas.
Mr. President of the International Court of Justice, Judge Yuji Ishikawa, allow me to start by congratulating you on your election to preside this court, and also to extend a nod to Judges Juan Manuel Gomez Robledo and Leonardo Nemes Caldeira Branch, both of whom I had the honor and privilege to meet and work with previously, and whose presence amongst you only confirms the degree of excellence of this highest court. Distinguished members of the court, it is an honor to speak on behalf of Brazil before the International Court of Justice, the principal judicial organ of the United Nations. We are gathered in this chamber to fulfill yet another stage of the mandate entrusted to this court by the United Nations General Assembly, which, through Resolution 79-232 of December 19, 2024, requested this court to render an advisory opinion on Israel's obligations regarding the presence and activities of the United Nations, other international organizations, and third-party states in relation to the occupied Palestinian territory. Brazil, alongside 52 other countries, co-sponsored the resolution and submitted a written statement to the court on the 28th of February, grounding our stance in our unwavering commitment to promoting international law and recognizing the crucial role of the International Court of Justice in fostering justice and peace. In the first phase of the proceedings, over 40 countries and international organizations chose to participate and furnish elements to support the court's deliberation. The widespread engagement highlights not only the importance of the matter at hand, but also the grave concern that Israel's actions in Palestine, not only in Gaza, but also in the West Bank, including East Jerusalem, have sparked within the international community. The ongoing catastrophe in Gaza, now reaching 18 months, has already claimed over 51,000 lives, most of whom women and children. After a brief ceasefire, during which hostages were released and desperately needed humanitarian aid was temporarily allowed to reach the population of Gaza, Israel resumed blocking food, medicine, and other essential supplies from entering the territory, restarted its attacks, and launched a new ground offensive in Gaza. In this troubling context, the present advisory opinion is sorely and urgently needed. Mr. President, the written statement submitted by Brazil expresses the view that the court has jurisdiction to issue the requested advisory opinion in accordance with Article 65.1 of its statute. There is, therefore, no reason for the court to refrain from issuing the requested advisory opinion. The issue before the court does not constitute a bilateral dispute that would warrant the non-exercise of its jurisdiction. On the contrary, it concerns legal obligations in a general sense within the scope of multilateral agreements and treaties, which must be complied with and respected. Distinguished judges, the right of the Palestinian people to self-determination has already been recognized by this court. Self-determination is one of the essential principles of international law, explicitly enshrined in the United Nations Charter and considered by the General Assembly as an inseparable element of fundamental human rights. As stated by the court, self-determination entails, among other elements, the right to territorial integrity and the right to freely determine its political status and to pursue its economic, social, and cultural development. Indeed, the General Assembly has repeatedly affirmed the Palestinian people's right to self-determination, including the right to an independent and sovereign state of Palestine. Other United Nations bodies, such as the Human Rights Council, have done the same. In its advisory opinion on the legal consequences of Israel's practices and policies in the occupied Palestinian territory, including East Jerusalem, this court stated that Israel, as the occupying power, has the obligation not to impede the Palestinian people from exercising its right to self-determination, including its right to an independent and sovereign state over the entirety of the occupied Palestinian territory. In this regard, Brazil contends and hopes that the court will acknowledge that all the measures systematically adopted by Israel to impede or hinder the presence and activities of the United Nations, other international organizations, and third-party states in the occupied Palestinian territory blatantly violate not only the Palestinian right to self-determination, but also other fundamental obligations under general international law. Mr. President, the United Nations Relief and Works Agency for Palestine Refugees in the Near East, UNRWA, was established by the General Assembly in 1949 to provide assistance to Palestinian refugees. Only the General Assembly has the authority to review or revoke its mandate, which cannot be subjected to restrictions imposed by any domestic legislation. UNRWA is the backbone of the United Nations humanitarian operations in favor of Palestinian refugees, providing education, healthcare, social services, and emergency assistance. It provides aid for over 6 million people. Its presence and work are even more urgent in the current context of near-total destruction in Gaza, where it serves over 2 million people. In 2024, contrary to international law, Israel passed 2 bills aimed at severely hindering UNRWA's operations within the occupied Palestinian territory, including East Jerusalem. At the time, Brazil immediately expressed its grave concern regarding this measure. We emphasize that it constitutes a blatant violation of international law in direct opposition to binding decisions of this court related to the occupying power's obligation to ensure humanitarian access to the citizens of the occupied Palestinian territory. As a member of UNRWA's Advisory Commission, in which it currently holds one of the two vice presidencies, Brazil urged the Israeli government to refrain from implementing these provisions in order to allow UNRWA's work to continue in all the occupied Palestinian territory. We regret that Israel has not revisited this measure, having instead undertaken measures to prevent UNRWA from carrying out its activities, especially in East Jerusalem. And we hope that this court will declare the absolute illegality of these actions. There is no realistic alternative to UNRWA in providing services and assistance to the Palestinian refugees. Any attempt to obstruct UNRWA's operations, whether through legislative, financial, or physical barriers, does not alter the established rights of Palestinian refugees. Hindering or undermining the ability of UNRWA to fulfill its mandate does not alter the established legal protections afforded to Palestinian refugees. Both as the occupying power as well as a member of the United Nations, Israel is obligated to facilitate and enable UNRWA's operations in the occupied Palestinian territory. It cannot interfere with or obstruct the exercise of this mandate, which was established by the General Assembly. Distinguished judges, I will now make specific remarks regarding Israel's obligations as an occupying power. In its Wall advisory opinion, the court confirmed that the Fourth Geneva Convention applies to any territory occupied following an armed conflict between high contracting parties. Israel and Jordan were both parties to the convention when the 1967 conflict broke out. Therefore, the court found that the convention applies to the Palestinian territory occupied by Israel since that time. This position had already been asserted by the Security Council in Resolutions 636 and 641. In its 2024 advisory opinion, the court reaffirmed that the occupied Palestinian territory is a single territorial unit and that Gaza remains an integral part of the area occupied by Israel in 1967. Although Israel had withdrawn its military presence from Gaza in 2005, it continued to exercise control over the territory in key ways, including through restrictions on movement, border control, taxation, and military operations in the buffer zone. This control has terrifyingly evolved since October 2023. As an occupying power, Israel has legal obligations under the law of occupation. The occupying power must administer the territory for the benefit of the local population while refraining from any acts of sovereignty. The obligations of an occupying power are clearly outlined in the relevant conventions and consistently restated in this court's opinions and in permanent resolutions of the United Nations General Assembly and Security Council. Israel must guarantee public order and safety while respecting local laws. It must also ensure access to essential services, including education, medical care, food, and humanitarian aid. Any failure to meet these obligations constitutes a blatant violation of international law. In other words, the international obligation to protect the civilian population is not limited to the duty of refraining from attacking civilians or international organizations or third states providing humanitarian assistance. In fact, it embodies the obligation to respect and ensure respect, which, in any unbiased view, also entails the positive duty to facilitate such assistance as provided for example, in Security Council Resolution 2720 of 2023, which demands the facilitation and enablement of the immediate safe, and unhindered delivery of humanitarian assistance. In the proceedings instituted by South Africa against Israel concerning the application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, this court issued on 26 January 2024 provisional measures ordering Israel to allow the urgent provision of humanitarian aid. On the 28th of March 2024, the court reinforced this obligation, ordering Israel to ensure the delivery of food, water, fuel, electricity, medical supplies, and shelter in full cooperation with the United Nations. Furthermore, the court ruled that Israel's military must not obstruct humanitarian assistance or commit acts that violate the rights of Palestinians in Gaza under the Genocide Convention. Under Article 94 of the UN Charter, these measures are binding. Beyond legal restrictions, physical barriers to humanitarian assistance, such as border closures, travel restrictions, and denial of re-entry, are also unacceptable. These actions only deepen the suffering of the Palestinian people. Israel cannot prohibit, restrict, or hinder the United Nations, other international organizations, or third states from providing humanitarian assistance in the occupied Palestinian territory. The situation in the occupied Palestinian territory is not only a humanitarian tragedy and a political disaster, but it also entails serious breaches of peremptory norms of international law. The principles at stake, self-determination, the prohibition of annexation, and the protection of civilians under occupation are at the core of international law. Compliance with the Fourth Geneva Convention and the rulings of this court is not optional. It is a legal imperative. Under these conditions, Israel cannot invoke domestic law to exempt itself from the responsibility arising from these obligations. In line with what this court affirmed in its 1996 advisory opinion on the legality of the threat of use of nuclear weapons, paragraph 79, and I quote, "A great many rules of humanitarian law applicable in armed conflict are so fundamental to the respect of the human person and elementary considerations as humanity," as the court put it in its judgment of 9 April 1949 in the Corfu Channel case, that the Hague and Geneva Conventions have enjoyed a broad accession. Further, these fundamental rules are to be observed by all states, whether or not they have ratified the conventions that contain them, because they constitute intransgressible principles of international customary law. End of quote. Mr. President, Brazil also wishes to highlight Israel's obligations, not only as an occupying power and under the international humanitarian law, but also as a member of the United Nations. This encompasses obligations concerning the privileges and immunities of the United Nations and its agencies, particularly UNRWA. The UN Charter, in Article 2, Paragraph 3, established that all member states must fulfill their obligations in good faith. Additionally, Article 2, Paragraph 5 mandates that all states provide the United Nations with every assistance necessary for the implementation of its actions. Consequently, Israel is legally required to facilitate UNRWA's operations in accordance with the relevant decisions of competent UN organs, including the General Assembly Resolution 302 and subsequent resolutions that have consistently renewed UNRWA's mandate. Furthermore, all UN member states must respect the privileges and immunities granted to the organization, its subsidiary bodies, and specialized agencies. Article 105 of the Charter affirms that the United Nations shall enjoy, in the territory of each member, the privileges and immunities necessary for the fulfillment of its purposes. This protection extends to representatives of member states and officials of the organization, ensuring their ability to exercise their functions independently. Since 1949, Israel has been a party to the Convention on the Privileges and Immunities of the United Nations, the General Convention, which applies to UNRWA as a subsidiary body of the General Assembly and therefore an integral part of the UN system. The General Convention clearly stipulates in Section 3 that UN premises are inviolable and that UN property and assets, regardless of location, are immune from search, requisition, confiscation, expropriation, and any other form of interference, whether by executive, administrative, judicial, or legislative action. Additionally, the organization and its property are exempt from all direct taxes under Section 7. United Nations officials also benefit from specific protections under Section 18 of the General Convention, including immunity from legal proceedings regarding acts performed in their official capacity, exemption from taxation on their salaries, and immunity from national service obligations. These officials, along with their families, are protected from immigration restrictions and granted privileges like those enjoyed by diplomatic personnel. Experts on UN missions are also granted necessary immunities to ensure the independent exercise of their functions, including immunity from arrest, detention, and legal proceedings as established in Section 22. Additionally, the General Convention mandates that the United Nations laissez-passer be recognized as a valid travel document by all member states in Section 24, and that visa applications from UN personnel traveling for official business be processed expeditiously, Section 25. Israel has long recognized these obligations. The exchange of letters constituting the Provisional Agreement between UNRWA and Israel of 14 June 1967, known as the Kameh-Michelmore Agreement, explicitly confirmed that the General Convention governs the relationship between Israel and UNRWA. However, Israel's obligations towards the United Nations and its agencies do not derive from this bilateral agreement. As established in the General Convention, to which Israel is still a party, they exist independently under international law and remain binding, regardless of the recent enactment in the Israeli Knesset of the unlawful piece of legislation aimed at ceasing UNRWA's operation. Israel, therefore, cannot invoke the termination of the Kameh-Michelmore Agreement as justification for failing to uphold its obligations under the UN Charter and the General Convention. Moreover, any alleged misconduct by UN personnel must be addressed exclusively through the mechanisms established in the General Convention. This does not alter Israel's duty to respect the inviolability of UN premises as a principle of fundamental character already underscored by this court. As such, military expediency cannot justify violations of UN privileges and immunities. Brazil also underscores that Israel cannot rely on its domestic laws, including recent legislative measures, to evade compliance with its international commitments. Article 27 of the Vienna Convention on the Law of the Treaties unequivocally affirms that states cannot invoke their national laws as a justification for failure to perform their international obligations. Israel, as a state party to the UN Charter, has a binding legal duty to facilitate UNRWA's work in the occupied Palestinian territory. The issue is not merely one of technicalities or bureaucratic maneuvering. The lives of millions of Palestinians depend on the provision of humanitarian assistance, and this court's opinion is crucial in reaffirming Israel's legal obligations toward the United Nations and its agencies. Israel's failure to facilitate UNRWA's operations as a means of obstructing humanitarian assistance constitutes a direct violation of its international legal obligations. Therefore, Brazil respectfully urges the International Court of Justice to affirm Israel's obligations under international law concerning the privileges and immunities of the United Nations, and to demand that Israel cease all measures aimed at restricting the activities of UNRWA in the occupied Palestinian territory. Only through full cooperation with the United Nations can Israel comply with its obligations under the UN Charter, the Fourth Geneva Convention, and other binding international legal instruments. Distinguished members of the Court, in recent weeks, new and severe incidents of direct attacks by Israel against staff of international organizations and humanitarian aid providers continued to occur. On the 30th of March, the bodies of 15 humanitarian workers from the Palestinian Red Crescent, Civil Defense, and UNRWA were discovered in Rafah, buried in a mass grave, having been killed by Israeli forces while participating in rescue operations in the southern Gaza Strip the previous week. In April, Israel bombed a building in the Jabalia refugee camp in the northern Gaza Strip, which housed a clinic operated by UNRWA. The clinic had been turned into an improvised shelter for Palestinians displaced by the conflict. The attack caused at least 19 deaths, including that of 9 children. Over 51,000 Palestinians have lost their lives in Gaza. Hundreds of humanitarian workers whose work was solely aimed at saving lives or providing some relief to a desperate population have also been killed. It is within this context that the present advisory opinion is framed. For the reasons presented above, Brazil reaffirms and respectfully invites the Court to declare that the Court has and should exercise its advisory jurisdiction. B, the Palestinian people have the inalienable right to self-determination and to their independent sovereign state, which includes the right to freely establish diplomatic relations and permanent diplomatic missions without external interference. C, as the occupying power, Israel must comply with international humanitarian law, including the Hague Regulations and the Fourth Geneva Convention. Israel is therefore under a non-derogable obligation not only to refrain from impeding or hindering the presence and activities of the United Nations, other international organizations, and third-party states in the occupied Palestinian territory, but also to facilitate and enable the immediate, safe, and unhindered delivery of humanitarian assistance at scale directly to the Palestinian civilian population in the occupied Palestinian territory. D, as a member of the United Nations, Israel must fulfill in good faith the obligations assumed by it in accordance with the Charter, including the obligation to give the United Nations and its agencies every assistance in any action it takes in accordance with the Charter. And E, Israel is under the obligation to respect the privileges and immunities of the United Nations and its agencies in accordance with the Charter and the General Convention on the Privileges and Immunities of the United Nations. We are confident that these are the inescapable conclusions that this Court will reach. Thank you.
I thank the representative of Brazil for his presentation. Before I invite the next delegation to take the floor, the Court will observe a coffee break of 15 minutes. The hearing is suspended.
La Cour.
Please be seated. The sitting is resumed. I now invite the next participating delegation, Chile, to address the court, and I call His Excellency Claudio Troncoso to the podium. You have the floor, sir.
Mr. President, members of the court, it is an honor to appear before you in these advisory proceedings on behalf of the Republic of Chile. The question submitted to the court is urgent and comes at a time when international law and the relevance of international organizations are as important as they have ever been. In Chile's view, an opinion of the court on this matter is pivotal to affirming and upholding the rule of international law and reinforcing the legitimacy of international norms. Chile recognizes that these proceedings are rooted in the context of the complex situation in the occupied Palestinian territories. Chile has continuously supported the self-determination of the Palestinian people, advocating for peace and recognizing the right of both states to exist and the right of the people who inhabit them to live a dignified and safe life. In this regard, Chile would like to stress its firm condemnation of all violation of international law by all parties to the conflict, including the attacks conducted by Hamas on 7 October 2023 and the kidnapping of individuals whose immediate and unconditional release Chile demands. When it comes to human suffering, each event is a tragedy. In this presentation, we will develop 3 key points. First, I will address the jurisdiction of the court to render an advisory opinion and, in particular, the absence of compelling reasons to decline it. Second, I will address the scope of the question presented to the court by the General Assembly and the applicability of the obligations that have already been noted by most delegations in the written phase of the proceedings. And lastly, Mrs. Valeria Chiappini will address the question of privileges and immunities of international organizations. Moving to the first point, it is Chile's position that the court has jurisdiction to give the requested advisory opinion, and that there are no compelling reasons for the court to refuse to do so. Some states have argued in the present proceedings that an advisory opinion would prejudge essential elements relevant to a pending case before this court, namely the proceedings brought by South Africa against Israel regarding the application of the Genocide Convention. Chile recalls that this court made clear in its interpretation of peace treaties advisory opinion that the court could decline to exercise its advisory jurisdiction in such cases where, and I quote, the question put to it was directly related to the main point of a dispute actually pending between two states, so that answering the question would be substantially equivalent to deciding the dispute between the parties. As was the case in interpretation of peace treaties, the question put to the court in the present proceedings does not touch the merits of the aforementioned pending dispute, and therefore, I quote, the legal position of the parties to this dispute cannot be in any way compromised by the answers that the court may give to the question put to it. In the pending dispute, South Africa is claiming that Israel is in breach of its obligations under the Genocide Convention. Thus, the relevant question for the court is whether the acts and omissions by Israel complained of by South Africa are genocidal in character and are intended to bring about the destruction of a substantial part of the Palestinian national, racial, and ethnic group. On the other hand, the question raised here concerns the obligation of Israel in relation to the presence and activities of the United Nations, including its agencies and bodies, other international organizations, and third states, which, as made clear by the delegations that have preceded me, encompass obligations that arise from several bodies of law, including international humanitarian law, international and human rights law, and the privileges and immunities of international organizations. Therefore, although the provision of humanitarian assistance is an issue that arose in the case concerning the application of the Genocide Convention in the context of provisional measures, and it's also relevant to the present proceedings, Chile submits that it's not a question that directly relates to the court dispute of that case. Indeed, by answering the question put before it, the court would not be deciding any aspect of the dispute between the parties in the contentious proceeding, because there are no direct links between the questions raised in the case concerning the application of Genocide Convention and the question put to the court in the present proceedings. Thus, rendering an advisory opinion would not compromise the legal positions of the parties to the dispute, nor the fairness of the proceedings. Consequently, there are no compelling reasons for the court to refuse to render the advisory opinion. Mr. President, members of the court, this leads me to my second point regarding the scope of the question presented to the court and the applicable rules. The court has had the opportunity to make findings in relation to the situation of the occupied Palestinian territory on two occasions. First, on 9 July 2004, in its advisory opinion regarding the legal consequences of the construction of a wall, and second, 20 years later, on 19 July 2024, in its advisory opinion regarding the legal consequences that arise from Israel's practices and policies in the OPT. In this context, the present proceedings are meant to complement the aforementioned opinions by addressing questions that had not yet been put before the court and consequently have not been answered. In particular, while the previous advisory opinions address the obligations that Israel has in relation to Palestinian people, the present question seeks to identify the obligations that Israel has toward other relevant actors operating in and in relation to the occupied Palestinian territory. More specifically, the question refers to the United Nations, including its agencies and bodies, other international organizations, and third states. The obligations that the court was requested to identify relate to all international organizations and states operating in and in relation to the OPT. However, Chile requests that the court take note of the grave concern expressed by the General Assembly in the preamble of its resolution 79/232, which informs the present request from advisory opinion in relation to, and I quote, plans and measures, including legislation adopted by Israel to interfere with or obstruct the presence and operation of the United Nations and the United Nations entities and organizations, including the United Nations Relief and Works Agency for Palestine refugees in the Near East. End of quote. As was submitted in our written statement, it is Chile's position that the relevant obligations arise from Israel's dual role as both an occupying power and a member of the United Nations. First, in its role as an occupying power, Israel is bound by international humanitarian law, particularly by the law of occupation and international human rights law where applicable. While it's true, as some have argued, that international humanitarian law does not directly focus on interaction between the occupying power and international organization or third state, it does focus on the protection of civilians and the occupied population. In that context, it establishes obligations to provide humanitarian relief and basic services to the occupied population. Furthermore, the Fourth Geneva Convention, to which Israel is a party, establishes a specific obligation for the occupying power to grant any relief organization all facilities necessary for it to achieve its purpose within the bounds set by military or security considerations. Chile notes that under Article 142 of the Fourth Geneva Convention, of the scope of the activities that may be undertaken by relief organizations is quite broad and would certainly encompass the activities of all 13 United Nations entities that maintain an ongoing presence in the OPT, as has been identified by the UN Secretariat in the present proceedings. As clarified by the International Committee of the Red Cross in its 1958 commentary to Article 30 of the Fourth Geneva Convention, the obligation of the occupying power to grant all facilities to relief organizations is not met by merely authorizing them to carry out their work. Rather, the occupying power must facilitate and promote their task. This means that it must, and I quote, take all necessary steps to allow approved organizations to take rapid and effective action wherever they ask to give assistance. End of quote. While this obligation is certainly limited by military necessity and security needs, this reservation must be interpreted restrictively and should not be read as a carte blanche for completely prohibiting the activities of such organizations, especially when they have been given a mandate to address the occupied population of a particular area by the General Assembly. Indeed, such limitations must only be imposed in good faith, and, I quote, shall not hinder the supply of effective and adequate relief to all protected persons, end of quote. For these reasons, the occupying power should show moderation in their use of this reservation, applying it only in cases of real necessity in an exceptional and temporary manner. These measures can never result in the paralysis of the relief effort. And while they last, the occupying power must make suitable arrangement on behalf of the protected population. Turning next to Israel's second role as a UN member state. Israel's obligation stem mainly from the UN Charter and the Convention on the Privileges and Immunities of the United Nations. For the sake of time, Chile directs the Court's attention to its written submissions for the complete identification of all the relevant obligations that are applicable, and would like to highlight here the duty of all UN member states to collaborate with the United Nations enshrined in Article 2, Paragraph 5 and 56 of the UN Charter. It is Chile's position that this duty includes all bodies, agencies, and subsidiary organs of the United Nations, and involves not only the observance and implementation of the UN policies and decisions, but also an obligation to cooperate in good faith with the organizations and abstain from obstructing their mandate. Your Excellencies, while this duty certainly applies in relation to binding Security Council decisions, contrary to what has been argued by some participants in the present proceedings, Chile submits that this duty does not exclusively apply to action taken by the Security Council in accordance to Chapter 7. Indeed, this Court has contradicted such narrow conception of the duty to collaborate in two ways. First, this Court made clear that the Security Council can make binding decisions in exercise of any of its powers, not only those concerning enforcement actions under Chapter 7. Second, this Court affirmed that, and I quote, the effective working of the organization, the accomplishment of its task, and the independence and effectiveness of the work of its agents, end of quote, requires the strict observance of the duty to cooperate under Article 2.5 of the UN Charter. Further, considering that the obligations contained in Article 2.5 is one of the principles of the organization under which member states must act in order to achieve the purpose of the United Nations, it follows that this duty of cooperation applies to activities of the organization and all its organs and agencies. A more restrictive interpretation would render this provision meaningless by limiting the scope of the principles of the Charter only to Article 25. Nevertheless, even if the Court were to find that Article 2.5 only refers to Security Council decisions, Chile submits that the Security Council has decided to vest Israel with specific obligations to allow, facilitate, and enable the safe and unhindered delivery of humanitarian assistance in the OPT, and to, I quote, ensure the safety and security of United Nations and associated personnel, those of its specialized agencies, and all other personnel engaged in humanitarian relief activities consistent with international humanitarian law, with prejudice to the freedoms of movement and access, end of quote. Mr. President, with this, I conclude the first part of the Chile's presentation, and I kindly request that you give the floor to Mrs. Chiappini to address our last key point.
I thank Mr. Troncoso. I now give the floor to Ms. Valeria Chiappini. You have the floor, madam.
Mr. President, members of the Court, it is an honor to appear before you on behalf of the Republic of Chile. In the remaining time, I will address the general obligation of all UN member states to accord to the United Nations such privileges and immunities as are necessary for the fulfillment of its purposes under Article 105 of the UN Charter. This obligation is further detailed in the Convention on the Privileges and Immunities of the United Nations, which I will herein refer to as the General Convention. This obligation is broad in scope and applies to all principal and subsidiary organs of the United Nations, whether or not member states have entered into any further agreement specifying them, or even if they have terminated such agreements. Concerning this obligation, Chile would like to emphasize that member states have a duty to guarantee immunity of jurisdiction and execution for the United Nations and its staff, and the inviolability of its premises, archives, and documents in a similar manner as those granted to diplomatic missions. To put it differently, these privileges and immunities are not subject to any qualification whatsoever. Nevertheless, some participants in the present proceedings have argued that these obligations would not be applicable where legitimate security concerns of a member state are undermined by an abuse of the agency's privileges and immunities. This, however, is not correct. The object and purpose of these privileges and immunities is to ensure the independence of the organization and to guarantee that it carries out its mandate without any undue interference or financial gain by the host state. Indeed, these privileges and immunities are only limited by that which is necessary for the organization's proper functioning. In short, United Nations member states are bound to accord the privileges and immunities that are necessary for the organization to perform their functions independently, effectively, and impartially. In this regard, while Chile condemns any abuse of these privileges and immunities that may occur, Chile recalls that member states are not allowed to take unilateral action against the privileges and immunities of the organization, its bodies, agencies, and staff in the presence of a perceived abuse. A specific provision to this effect was included in the Convention on the Privileges and Immunities of the Specialized Agencies, adopted 1 year after the General Convention. Section 24 of the Convention of the Specialized Agencies provides a mechanism for state parties to resolve a situation in which they consider there has been an abuse of a privilege or immunity, mandating them to engage in consultations with the concerned agency. If such consultations fail, it is this very court who needs to determine, through an advisory opinion, whether such an abuse has occurred before any measure can be taken by the host state. The original proposal of Subcommittee 1 of the 6th Committee of the General Assembly was granting state parties to that convention, in the event of such an abuse, the right to denounce it and terminate any obligation to give privileges and immunities to the specialized agencies of which it would still remain a member. However, that proposal was met with several objections, including, first, that if such a provision were to be incorporated, the Specialized Agencies Convention would diverge considerably from the General Convention, which does not grant such right of denunciation. Second, the provision would contradict the already accepted principle that specialized agencies should receive appropriate privileges and immunities as necessary to carry out their mandate. And third, it seemed wrong in principle to permit a state to have the advantages of being a member of a specialized agency while denying it privileges and immunities necessary for its operations. To be sure, Your Excellencies, while there is no similar provision contained in the General Convention, the same considerations still stand. Namely, permitting a member state to unilaterally strip the organization and its officials of their necessary privileges and immunities would defeat their very object and purpose. Indeed, in the United States diplomatic and consular staff in Tehran case, the court affirmed the fundamental character of the principle of inviolability and consequently found that the conduct of Iran would have been unjustified even if the alleged criminal activities of the United States had been established, mainly because the Vienna Conventions on Diplomatic and Consular Relations contained express provisions to address the abuse of privileges and immunities. Similarly, the General Convention offers sufficient assurances against the abuse of privileges and immunities. Sections 20 and 23 clearly establish, and I quote, that privileges and immunities are granted to officials and experts in the interest of the United Nations and not for the personal benefit of the individuals themselves, end of quote, and provide the Secretary General with the right and duty to waive the immunity of any official or expert in mission where such immunity would impede the course of justice. In addition, Section 21 of the General Convention provides an obligation to the United Nations, and I quote, to cooperate at all times with the appropriate authorities of members to facilitate the proper administration of justice, secure the observance of police regulations, and prevent the occurrence of any abuse in connection with the privileges, immunities, and facilities, end of quote. Mr. President, members of the court, Chile further recalls that under international law, measures of self-help are strictly limited to measures of retortion, countermeasures, and self-defense, and where tolerated, are always deemed a measure of last resort. In this regard, it is a well-established rule of international law that countermeasures cannot be exercised against privileges and immunities of any kind, including the inviolability of organs or agents of an international organization and of its premises, archives, and documents. Lastly, Chile notes, as explained by the UN Secretariat, that any concerns regarding the abuse of privileges and immunities of the organization must be properly brought to its attention to be considered in the context of its legal framework. In this connection, Chile stresses the importance that the relevant UN organs, including the General Assembly, strengthen its control over its agencies and subsidiary organs. If, however, after the appropriate intervention of the relevant organs, any issue remains unresolved, the proper dispute resolution mechanism is already established in Section 30 of the General Convention. Your Excellencies, the regime of privileges and immunities of international organizations is indispensable for the independent and effective functioning of all UN organs, including this very court. The erosion of these norms through unilateral action not only undermines legal certainty, but jeopardizes the very fabric of multilateral cooperation upon which the international order rests. Mr. President, members of the court, this concludes Chile's presentation. Thank you for your kind attention.
I thank the representatives of Chile for their presentation. I now invite the next participating delegation, Spain, to address the court, and I call upon Her Excellency Ambassador Consuelo Bermenia to take the floor. Madam, you have the floor.
Mr. President, distinguished members of the Court, it is an honor to address this Court on behalf of the Kingdom of Spain. Spain is participating in these advisory proceedings in order to cooperate with the International Court of Justice in the exercise of its advisory powers. Spain's oral statement will follow the same structure as the written observations submitted on February. It will, therefore, make a distinction between Israel's obligations regarding the presence and activities of the United Nations, other international organizations, and third states in the occupied Palestinian territory, and with respect to that territory, as a member state of the United Nations on the one hand, and as an occupying power on the other. This distinction is to some extent a formal one, made for illustrative purposes, since the legal questions raised are inextricably intertwined. However, this formal distinction, which is a direct response to the question asked by the General Assembly, is useful in this context, as it calls for the obligations at stake of the member states of the UN nations pursuant to the Charter of the United Nations and to international law to be considered separately. Certainly, the obligations to be examined are comprised in the following: rules in the Charter of the UN directly tied to the activities of the UN to maintain international peace and security. Rules in the Convention on the Privileges and Immunities of the UN Nations of 1946, which form part of a wider body of diplomatic law. Rules that determine the extent of the obligations assumed freely and in writing between subjects of international law, and rules that refer to the protection of people and their property in the context of armed conflict and periods of crisis, which therefore aim to safeguard human dignity. In other words, these rules either regulate vital aspects of international law and require states to act in a certain way in relation to the protection of central legal principles of international law, such as sovereignty, sustaining peace, and elementary considerations of humanity, or are of a marked instrumental or procedural nature and aimed to safeguard and facilitate relations between subjects of international law in the form of treaties or immunities, even or especially in crisis situations. Because of this, they are rules that go beyond the interest of a single state and presuppose the existence of a world community based on multilateralism and compliance with international law. Spain's statement will have the following structure. In the first part, I will address Israel's obligations as a member state of the United Nations. In the second part, we will examine Israel's obligations as an occupying power. Israel was admitted as a member state of the United Nations under the General Assembly Resolution 273, Roman III, on 11 May 1949. As a member state, Israel must respect the independence and autonomy of the United Nations and assist it in carrying out its activities. Article 2.5 of the Charter sets out this obligation in general terms. All members shall give the United Nations every assistance in any action it takes in accordance with the present Charter. This obligation is necessarily linked to the principle of autonomy and independence of the UN, contained in Articles 100 and 104 of the Charter, which is a logical consequence of the recognition of international legal personality of the United Nations. In accordance with this principle of autonomy and independence, the United Nations is responsible for 1. Determining the matters that fail within its mandate, 2. Selecting the most appropriate means of addressing those matters, and 3, if appropriate, establishing the organs, programs, and agencies it considers best suited to perform the related functions. In exercising these responsibilities, the UN must follow the established procedures. Member states which participate in the decision-making process of the organization must cooperate in good faith with the UN. Nothing prevents states from exercising their rights as member states of the United Nations and calling for amendments to previous decisions adopted by its bodies. They may do so with the sole limit of always acting in accordance with the Charter and pursuant to the decision-making procedures of the competent bodies, and therefore not by means of an unilateral decision. In Resolution 79/81, Peaceful Settlement of the Question of Palestine, which was adopted on the 3rd of December of 2024, the General Assembly reaffirmed the permanent responsibility of the United Nations with regard to the question of Palestine until it is resolved, in all aspects in accordance with international law and relevant resolutions. Said responsibility was assumed by the United Nations early in its existence. The duty of member states of the United Nations to assist the organization, which we have described in general terms, crystallizes here as two obligations. The first, to cooperate in good faith with the agencies and bodies of the UN, including UNRWA, and the second, to not prevent them from carrying out their activities. In this context, we must highlight the central role that the UN has attributed to UNRWA, which was created by virtue of General Assembly Resolution 302, Roman IV, on the 8th of December 1949, on assistance to Palestine refugees, and whose mandate has been continuously renewed to date. This mandate was established by the General Assembly in accordance with applicable procedure and may only be modified by the General Assembly. No state may unilaterally change or cancel it. As a member state of the UN and a state party to the Convention of 1946, Israel is not only required to respect the privileges and immunities of the United Nations agencies, funds and programs, especially UNRWA, both in the occupied Palestinian territory and in Israel, but also to abstain from carrying out any executive, administrative, judicial or legislative action that curtails, prevents or impedes the effective enjoyment of the privileges and immunities accorded to the United Nations and its staff. The extent and content of these privileges and immunities should be understood in functional terms. This functional nature does not empower states to unilaterally determine the extent of the recognized privileges and immunities of the organization, or to apply the Convention to a specific situation, or to unilaterally decide which organs, programs, and agencies are protected by the Convention, or to decide who falls within the categories of officials or experts on missions. Lastly, this functional nature does not authorize states to assess the conduct of staff and agents in the performance of their mandates. These functions are primarily competences of the Secretary General. This was established by the Court in paragraph 33 of its advisory opinion on difference relating to immunity from legal process of a special rapporteur on the Commission on Human Rights. On the other hand, the Convention includes a number of measures to guarantee good faith and mutual trust between the organization and its member states. For instance, the right and the duty recognized to the Secretary General in Article 5, Section 20, and Article 6, Section 23, to waive the immunity of any official or expert in any case where, in his opinion, the immunity would impede the course of justice and it can be waived without prejudice to the interests of the United Nations. And the obligation of the United Nations to cooperate with the authorities of member states to ensure the law is followed as set out on Article 5, Section 21. Similarly, Article 8, Sections 29 and 30 establish a system for settlement of any disputes that may arise between the organization and a member state regarding application of the privileges and immunities. These mechanisms allow state parties to protect their legitimate interests and rights and to call attention to alleged non-fulfillment of mandates by organs, agencies and officials of the United Nations, and even to advise of potential abuse of privileges and immunities. However, the mechanisms do not enable states to unilaterally judge the actions of the organs, agencies and officials, or to unilaterally deprive them of their recognized privileges and immunities. Either of these actions would go against obligations incumbent upon states. Mr. President, I will now set forth Spain's position regarding Israel's obligation with respect to the subjects of public international law deriving from its status as an occupying power. We will examine Israel's obligation under the international law of occupation. These obligations, which are part of relevant international treaties and customary law, international law, have been already referred by the International Court of Justice in its advisory opinions of 2004 and 2024. These obligations are: A, as the occupying power, Israel has no sovereignty over the occupied Palestinian territory and is legally obliged to refrain from exercising any acts of sovereignty. The enactment of the cessation laws and any measures taken by Israel in the occupied Palestinian territory on the basis of those laws and other applicable Israeli legislation appear to constitute an exercise of sovereign powers and are, therefore, inconsistent with Israel's obligations under international law. B. Israel has the obligation to administer the occupied Palestinian territory for the benefit of the local population. In its advisory opinion of 19 July 2024, the Court affirms that by virtue of its status as an occupying power, a state assumes a set of powers and duties with respect to the territory over which it exercises effective control. In this context, the occupying power bears a duty to administer the territory for the benefit of the local population. The nature and scope of these powers and duties are always premised on the same assumption, that occupation is a temporary situation to respond to military necessity, and it cannot transfer title of sovereignty to the occupying power. While Article 43 of the Hague Regulation does not, as such, specify the means by which the occupying power is required to fulfill this general duty, other, more specific rules of international humanitarian law give effect to this obligation. C. Israel has the obligation to ensure that the local population's basic needs are met. Paragraph 1 of Article 55 of the Fourth Geneva Convention imposes on the occupying power the obligation to meet the basic needs of the population to the fullest extent of the means available to it. The occupying power has the duty of ensuring the food and medical supplies of the population. It should, in particular, if the resources of the occupied territory are inadequate. Paragraph 1 of Article 69 of the Protocol additional to the Geneva Conventions complements and expands on the concept of basic needs, stating, in addition, to the duties specified in Article 55 of the Fourth Convention concerning food and medical supplies, the occupying power shall, to the fullest extent of the means available to it and without any adverse distinction, also ensure the provisions of clothing, bedding, means of shelter, other supplies essential to the survival of the civilian population of the occupied territory, and objects necessary for religious worship. D. Israel has the obligation to accept or allow the provisions of humanitarian assistance to the civilian population. Article 59 of the Fourth Geneva Convention imposes on the occupying power the obligation not only to agree, but also to facilitate the necessary relief schemes undertaken by other states or by impartial humanitarian organizations. This obligation is recalled by the Court in the order of the 26th of January 2024, indicating provisional measures, in which it affirms that Israel must take immediate and effective measures to enable the provision of urgently needed basic services and humanitarian assistance. Moreover, international humanitarian law places limitations on a state's discretion to withhold consent in situations of occupation. In case of necessity, the occupying power must agree to humanitarian assistance from the other states or from international organizations. E. Israel has the obligation to cooperate with the United Nations, international organizations, other states, and local authorities. The International Court of Justice reaffirmed this obligation in the specific case of Israel in its order of the 28th of March 2024, indicating provisional measures in the case application of the Convention of the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, where the court stated that Israel shall take the necessary and effective measures to ensure, without delay, in full cooperation with the United Nations, the unhindered provision at scale by all concerned of urgently needed basic services and humanitarian assistance, including food, water, electricity, fuel, shelter, clothing, hygiene and sanitation requirements, as well as medical supplies and medical care to Palestinians throughout Gaza, including by increasing the capacity and number of land crossing points and maintaining them open for as long as necessary. Even if the fulfillment of the obligation to facilitate the provisions of humanitarian assistance is subject to limitations for reasons of security, this right of objection must be interpreted in the light of the principles of proportionality and humanity. In addition, said right of objection must be interpreted in accordance with Article 47 of the Fourth Geneva Convention, which establishes that protected persons who are in occupied territory shall not be deprived in any case or in any manners whatsoever of the benefits of the present convention by any change introduced as a result of occupation of a territory into the institution. Lastly, we must examine the withdrawal by the occupying power of consent to the presence and activities of humanitarian organizations and other states. The law of cessation of UNRWA activities adopted by the Knesset unilaterally provided for the termination of the agreement constituted in the exchange of letters between Israel and UNRWA on the 14th of June 1967. Pursuant to international law, Israel does not have the right to unilaterally revoke the agreement with UNRWA, constituted by means of the aforementioned exchange of letters. Moreover, the general principle of the consent of states must not be considered in isolation, but in conjunction with other international obligations to which the State of Israel is subject. The obligations of an occupying power are relevant in determining whether a refusal or withdrawal of consent is in compliance with an occupying power's obligations under international law. In this regard, such termination must not only be in accordance with the laws of treaties, but also with international humanitarian law, international human rights law, and the right to self-determination. Israel's obligations concerning the presence and activities of the United Nations agencies, including UNRWA, draw their original legal basis from all the aforementioned conventions and obligations under the international law. Mr. President, distinguished members of the Court, I shall now conclude by summarizing Spain's position regarding the questions put to the Court in a context in which the Secretary-General of the United Nations recalled on the 14th of April that under international humanitarian law, in the whole or part of the population of an occupied territory is inadequately supplied, the occupying power shall agree to relief schemes on behalf of the said population and shall facilitate them by all the means at its disposal. The Secretary-General also recalled that under international humanitarian law, wounded and sick medical personnel and medical facilities, including hospitals, must be respected and protected. Article 2, paragraph 5 of the Charter of the United Nations provides that all members shall give the United Nations every assistance in any action it takes in accordance with the present Charter. In Resolution 79/81, the General Assembly reaffirmed the permanent responsibility of the United Nations with regard to the question of Palestine. It was in the context of such responsibility that UNRWA was created, with a clearly humanitarian and development-related mandate, which has been consistently renewed until the present day and which cannot be unilaterally amended or cancelled by a member state. UNRWA is being prevented from fulfilling its mandate by the laws adopted by the Knesset on the 28th of October 2024, which entered into force on the 30th of January this year. These laws and any subsequent measures to implement them must be considered incompatible with the obligations of Israel to provide assistance to the agency in the performance of its functions and the fulfillment of its mandate in Palestine. Moreover, Israel, as a member state of the United Nations and as a state party to the Convention on the Privileges and Immunities of the United Nations of 1946, is obliged to respect the privileges and immunities of the UN as regards the presence of the agencies, funds and programs of the United Nations, in particular UNRWA, both in the occupied Palestinian territory and in Israel. Certain actions attributable to Israel may be in conflict with the said privileges and immunities. Israel has occupied the Palestinian territory since 1967. In the words of the Court, by virtue of its status as an occupying power, a state assumes a set of powers and duties with respect to the territory over which exercises effective control. The illegality of the occupation does not release Israel from its obligations and responsibilities under international law towards the Palestinian population and towards other states. The powers and obligations of Israel with respect to the occupied Palestinian territory are governed by international humanitarian law. Articles 50, 55, 56, 59 and 60 of the Fourth Geneva Convention establish Israel's obligations to ensure and facilitate the fulfillment of the basic needs of the local civilian population, as previously stated by the Court. In the event that Israel fails to fulfill the aforementioned obligations, Israel has the obligation to accept humanitarian assistance for the civilian population. This obligation, provided for in Article 59 of the Fourth Geneva Convention, is well established in general international law. Fulfillment of the aforementioned obligations to facilitate humanitarian assistance may indeed be subject to limitations for reasons of security. However, this right of objection must be interpreted in the light of the principles of proportionality and humanity. Moreover, as assessed by the Court, such reasons do not exist in the present case. The laws adopted by the Knesset in October of 2024 constitute an arbitrary withholding of consent to humanitarian organizations, and in particular to UNRWA, to provide humanitarian assistance, and therefore a breach of international humanitarian law applicable to all occupying powers. In view of the above, it can be concluded that the prevention of the presence and activities of the United Nations, other international organizations, and other states in and in relation to the occupied Palestinian territory is a violation of both the norms of international human rights law applicable to Israel and to the right of self-determination. Thank you very much for your attention and your interest.
I thank the representative of Spain for her presentation. This concludes this afternoon's sitting. The oral proceedings will resume tomorrow at 10 a.m. in order for the court to hear the presentations of the United States of America, the Russian Federation, France, Hungary, and Indonesia. The sitting is closed.